But this sudden change of bench, because Justice Kartak was there, he could not have taken my case. Now there is a change of bench. There is one item number 3, it's supplementary. I will do and come. I just want to inform you.
Yesterday matter was listed, but could not release matter. So last 6 years.
Not this week. This week we are taking up a matter which will, I believe will take some days. Next week, give it to the court master, they will give it.
Item number 9.
9.
No, should I tell you, don't you the court paper? I'm taking copies from the other.
Okay. Consent of the other side, Mr.
Yes.
J. Das, counsel for the appellant. Place for adjournment. Prayer is allowed. List after 2 weeks.
For listing for criminal appeal lordship, for orders lordship. The last listed on lordship 1611.
Give it, they will make some adjustments.
Offline. People discuss on IM. Next week.
Give it to the court master, they will make some adjustments. Yes, item 1.
Item 1.
Lordship, kindly pass over the matter. But kindly pass over the matter for timely.
Just a moment.
Lordship wanted me to see that
Just a minute.
records to find out why the facsimile seal was different. In fact, I checked the records. Now, what I can say is the Lordship can see the police's statement, the IO statement, that makes it clear. My humble submission is that that can be the reason for the change. First, what had happened is
Just a moment.
Lord.
Page.
Lordship, I have
Okay.
seen the records, the evidence of PW, the evidence of PW 8,
8.
yes, 8.
Okay, that is in the paper book, page 15.
8, Lordship will see in book NCR to Jana. NCR.
LCR,
Now there what I can see is
page 15.
the items, they have seized the items on 21st. Thereafter, they have produced the contrabands before the court on 22nd. 23rd, Lordship will find that because what I can say is the same the samples which were made as representative samples under 52A were sent for FSL examination.
Okay.
Now, Lordship will see here, the 22nd, they place it before the court. Then the 3rd paragraph, Lordship will see. On that day, I made prayer before Honorable Court for seeing the original Caesar list. That is on 22nd, as well as exhibits number, MR number so-and-so in connection with the said case. Exhibit 6 is my prayer. Exhibit 6.1 is my signature. Is the signature of in charge CJM. This is what PW6 had stated. He being an employee of the CJM. They had put the signature. That day it happened, the entire process. Thereafter, he prepared inventory of the 3 numbers of suspected ganja packets because they had unloaded the entire 10 packets into 3 packets. That is also perhaps not very correct. They should not have unloaded it from the original packets, but they unloaded it to 3 packets. This is an admitted fact. Now he then 3 numbers of suspected ganja packets seized by Kulendra Hujuri on the day of incident, that is 21st. Exhibit 7 is the inventory report, is the signature of OC, which I know. Thereafter, Lordship will see Jyoti Lahan made prayer for certification of correctness of inventory. This is entire process given under 52A. Permit for taking photographs of the seized items in the inventory and certify such photographs as true and allow for taking representative samples in presence of the court and certify correctness of list of samples so drawn. Exhibit 8 is the prayer, Exhibit 8.1 is the signature, and 8.2 is the signature of in charge CJM. I, being the IO of the case, shown the prayer of Inspector Jyoti Lahan and inventory before the court. As per the prayer made by Jyoti Lahan, Honorable Court allowed me to collect sample of the seized articles in her presence and certified the correctness of inventory prepared by the OC. Accordingly, 3 samples weighing 25 grams each were drawn and marked as A1, B1 and C1. These are the only samples, 3 samples. From the said 3 packets of suspected ganja, after drawing samples, remaining ganja was sealed and marked as A, B and C. Photographs of the samples and seized ganja are taken. This must have been there. Now, Exhibit 9 is the order passed by the Honorable Court. The in charge is Yasmin. 9.1 is the signature of in charge. 9.2 is my signature. 10 is the photographs of the samples. 10.1 is the signature of in charge CJM. 11 is the photograph of
Just
seized
pass on that LCR for a moment.
lodge. Lordship, what I wanted to show is immediately thereafter, Lordship will find samples were sent to FSL, the same samples, A1, B1 and C1. Now, if we see the FSL examination, there it is written, one packet consisting of 3 samples are sent from the police, IO had sent. So that 3 samples is contained in one packet. And that one packet had IO or what, the SP Morigaon. But other samples had CJM signature, CJM Morigaon. That can be the only answer. A1, B1, C1 had CJM Bongaigaon, and the one packet which consisted of 3 samples, it contained SP Morigaon. I tried to find out whether there are separate samples for FSL and as representative samples, but I didn't find that. No evidence to that effect. Forwarding on that. So.
We are having some difficulty in following it because the exhibits are not serial.
Exhibits are A1, B1 and C1.
No, the exhibit file, the exhibits are not serial in serial order. First exhibit is exhibit 4, second, first exhibit
Let us say doesn't.
is exhibit 4, second exhibit is exhibit 19. Third page is the exhibit number.
In the paper book,
Two.
he has otherwise put it in a serial.
No,
manner.
no, this something we have to see in original.
Acha, acha.
Break up 1, 2, 3, 4 serial exhibit. It exhibit 4. And exhibit 19. Wrong up at the serial code.
I think it was, I think it was arranged as per the witness's statement. Could have been.
No, maybe, but it doesn't limit our power to have it serial.
Really got this better.
We'll do it, we'll pass an order in the order sheet to make it serial in serial order.
Acha, acha.
We'll take it after some time. Let it be arranged. We'll take it up after some time.
That is the only answer I could gather. Otherwise, why the decimal seal had changed, that is
No,
difficult.
there is a missing link.
Hmm.
There is a missing link. And
But
that's why the state police is required to have expert training.
That is so.
It's something which should not have happened. Because the explanation in a drug case must come from the record.
Yes,
There's a missing gap.
that can be, yes, that itself is a missing gap. But the dates when it was sent and the samplings were done and it was kept in Malkhana, thereafter it was sent to the FSL. Those dates
No,
otherwise
you see, we have not formulated our mind. We are just trying to assess the argument which was made on the last occasion. This will take some time because I'll take up the Sudhas's matter first. It will be rolled over.
Mr. Mishra is otherwise come soon.
Huh?
Mr. Mishra will come soon.
This way, if he comes, then your matter will be postponed to later part of the day. Please wait for some time. Yes, item 2. Yes.
My wife had deserted my lord in January.
White has come for orders.
My lord, just come for orders. My lord would kindly peruse order dated 3/2/24, the office of my lord. My lord, as per order dated 8/1/24 passed by this honorable court, my lord. It was directed that my lord, what had happened in the case is that, my lord, I had given a newspaper advertisement to reach out to my wife, informing her about this case, my lord, which we are conducting right now before this honorable court. But I haven't been able to contact her, my lord, in this case. Thereafter, my lord, this honorable court, by order dated 8/1/24, had directed the registry to contact the legal service authority of Udalguri district, where my wife resides, where her mother's house is, to contact her so that she is able to appear before this honorable court today. That my lord will file in office note dated 3/2/24.
No, whatever we were, the report has not come.
My lord, may I say no? Yes. My lord, in this case, my lord, my wife had deserted me way back in January 2019, my lord, along with my child. Thereafter, my lord, I had been trying to contact her ever since. Then, my lord, I had instituted one divorce case, my lord, on grounds of desertion. My lord would kindly have paid 18, my lord, once there of the appeal.
Yes.
My lord, this is my divorce petition, my lord, which I had filed. On ground of desertion, my lord, the relevant.
You are, what do you call, you are proceeding with the hearing of the matter? Ex parte without service report? You are out of mind?
My lord, yes, sir.
Please say it. We can't give you much time.
My
You
lord,
had to say something, say it. And you have gone into the merit of the matter. You are taking us to the documents where the service report is not complete and you say that I have to say something. Please say it.
to say, my lord, that in this case, my lord, in the earlier round of litigation also in the lower court, well, I have tried to contact my wife, my lord. In fact, the Jarigar of the lower court had also gone to her house, done the service to reach her.
That's enough. You want me to go through the Jarekar report of the trial court to give our service report, accept the service report? You have some sense of responsibility when making a statement? You come, do one thing, you pass an order, we'll take it up with the last item. You pass an order, we'll see how you write an order. Write it
I apologize.
and give a written order, we'll see, examine it, whether it is right or wrong. You do it. The court has to take responsibility of a service report. And you want me to take cognizance of the service report of the Jari Karak?
I apologize.
It's not a question of apology. How does the Jari Karak report is accepted in a trial court? Tell us. What does the Jari Karak report in the trial court should contain? Tell me.
I apologize. I apologize.
So, a trial court recording, a trial court proceedings, you want to take up the appellate matter and have a reliance on the placed on the trial court service report. Absolutely disgusting argument you are making. Have some sense of responsibility. You are asking a court to pass an order which will be illegal. And that too at 10 in the early parts of the day, when you have not even started a day. I don't forget faces so easily. I may be forgetful of names, but I don't forget a face. Don't put me to such a push me to such an extent where I pass when I make utterances against a lawyer in a demeaning manner. I don't want to do it. I want to live like a happy man, work for the day, go out smiling, come in smiling. Next day also I want to begin my day and end the day like that. I don't want to preach here, scold a lawyer like that. But take some responsibility in making a submission. You want us to make a service report in that? You pass an order, we'll see. You pass an order, write an order and show it to us how to write. It's not a question of apology, do it. You want us to pass an order? I am asking you to do it. You pass and show it to us. If it's acceptable, we'll accept it. Do it.
I'm extremely sorry, my lord. My lord, because this.
We await the service report. Let a reminder be sent to the concerned district judge to send a service report to the court pursuant to the office note dated. In terms of office note dated 3/2/2024, placed after 4 weeks. Just give us 2 minutes. Please sit down. Chill off period. Because I don't want to affect the next case. Give me 2 minutes. Yes. This will be the last item. John will be the last. I forget. Yeah, I forget. Yes, item 3.
It is because against an order that we paid. Shift booking order is at lecture 8, page 22. The last occasion, was an friend had appeared and.
Yes.
So that we wanted to file some objection, I have not received any copy of that. Some date.
Your Lordship, may I pray, Your Lordship? Lordship, conducting council D Hussain is not well, Your Lordship. Last occasion, on the same ground, adjournment was taken.
Oh, okay. Who is the counsel? Mr. D. Hussain.
D. Hussain. Give some time, Your Lordship.
Where is the IA? IA. Oh, delay is already condoned. Oh, okay, okay. Okay, we give you 10 days time then.
Okay.
10 days time will be today's 6th. 16th February,
I will be out of station, can it be on 19th?
19th. Okay. Held by then,
Okay, Lord.
for Mr. Arkari Chaudhary, learned DSGI, appearing for the appellant, as well as Mr.
RM,
R.
AM, Sundar.
A. Mazumdar, learned counsel for the respondent. Next panel, the learned counsel for the respondent, praise for and is granted 10 days time to file affidavit in, to file objection if any in the matter. With service copy to the learned DSGI. To start. List on 19 to 2024.
Oblige.
এতিয়া যে টাইমলি গৈছে এইটো এতিয়া মাতিব পাৰিম নেকি বস্তুটো চিৰিয়েল কৰিছো
Yes. Item 1.
Sampling. আপনি বুঝে
It was, is it? FSL 55. That will have. Period. For FSL. Another thing. अच्छा. Take it from her. Mohanlal is followed. Like, who is it between doing 14?
No.
Yes.
My lord, my submission for the purpose of suspension of sentence, my lord, I have given in a small write-up, my lord, before this court, my lord, that the identity of the sample could not be ascertained. More so, my lord, it was, the samples was lying with a police officer who was even not examined.
Full and heavy.
Huh.
Okay.
The samples were given to one, what was this, my lord?
Jyoti Lahore.
Girish Chandra Roy, PW8. If your lordship sees the statement of PW8, my lord, the samples were in the hands of Girish Chandra Roy, who took it to the FSL. Now, my lord, this connecting link, because there is a discrepancy in the specimen, that could have been proved by Girish Chandra Roy. Now, Girish Chandra Roy is not exact. And the samples were lying with Girish Chandra Roy for more than 24 hours, which is again not permissible under the scheme of the NDPS Act, my lord. And moreover, my lord, when the samples were exited, when it was entered, no Malkhana in charge, no register, Malkhana register was ever exhibited.
Yes. Yes. Yes, please continue.
Now, my lord, if your lordship sees the statement of PW.
Hello. Hello.
Lordship, kindly comes to PWC.
The samples went to the forensic on 24th. 24th it was received.
It's reflected in this.
Okay.
With a covering letter, with a forwarding letter, that they can break the seal and all.
Okay.
Now, when it was exited from the Malkhana, this case has been dealt very casually by the investigating officer, my lord, because my lord, your lordship will kindly appreciate. Once this, the contrabands were after, at the night when it was intercepted and this contraband, they were put inside the Malkhana. Next day morning on 22, they have exited it to produce it before the chief judicial magistrate. There is nothing on record to even remotely suggest that thereafter these samples and this contraband were again kept inside the Malkhana. Because that has to be true. On 23rd, they handed over to one Girish Chandra Rai. And that too by a forwarding of the additional superintendent, additional SP. He's now, from where additional SP comes, my lord, into the picture?
Additional SP.
No, sir, no.
Forwarding notice of additional fee.
Forwarding notice is of
Ah,
additional
forward.
SP, and in that forwarding notice, it says that it is, the evidence of PW8, it says that it was handed over to Girish Chandra Roy, PW8 statement, sir.
He is right.
Huh.
That is the statement.
Additional SP, I guess,
No,
No.
from the 8th.
He's a constable, I believe.
Achha.
it was in the custody of a constable entire night.
Achha, achha. Lahon is the additional SP.
Yes, Lahon is not examined. So the person who have sent the samples is not examined. The person in whose custody the sample was not examined. And this linked with the discrepancy in the specimen clearly raises a suspicion regarding the identity of the sample.
understand.
Yes.
No, my only, no, paper. My only submission is that 21st, it was seized. 22nd, it was taken to the court. 22nd, the entire process of 52A was followed. Certification, everything. They took out sample A1, B1 and C1. And then on 24th, they had sent it to you for FSL. And the FSL report shows, and it is written that the samples had the facsimile of CJM Bongaigaon. And then it was sent. FSL the official says that I get one person which consisted of 3 samples. And that one person had the facsimile of SP Bongaigaon. So what I can see is that the covering envelope, which consisted of 3 samples, had the SP Bongaigaon signature because it was police who had sent the items to FSL by packeting it. And samples had the facsimile of CJM Bongaigaon, it was done before the CJM. But the covering thing had the DSP. This is what I can see.
From where this is saying, I don't know.
No, because see the FSL report. Lordship will find the FSL report. And other numbers are same. Police station numbers and all are telling. These are same. Only fascinant seal which is creating problem here. Now, what is the word? Yeah, true. Because police have said, and they have that big packet thing. This is not there, but I have to somehow. Where is that FSL report? Lordship can find the FSL report at page 49. And 49 says, see, advising the examination of one parcel per messenger. This per messenger I'm not getting, maybe the.
Our messenger means it was sent via messenger.
One.
Roy, Chandra Roy, who is not a-
And then Lordship will see the second paragraph, mode in which parcel found to be packed on receipt and the description of seal. The parcel consisted of 3 exhibits enclosed in a sealed envelope cover. The facsimile of the seal was found to be superintendent of police. The one seal which covers all the 3 exhibits had that facsimile of SP. And 3 exhibits had the facsimile of CJM. Deduce, we have to deduce. Our photographs, Lordship can see the photographs. Photographs to halka loga na yaar. Yeah, Mark A, Mark B, Mark C. Why 6 photographs? The same that it was made. এইটো যিটো আছে এইটো এয়া হা এইটো 22 তাৰিখে হ'ল packets drawing samples image sealed and not just taken paperwork I informed writing to letter sample to be sent on 23rd. 23rd.
20
No, samples were sent on 23rd, not 24th.
Yes, 23rd, it was given
23rd,
to
next
Girish
day.
Chandra Rai. It was handed over to Girish.
No, samples were sent to FSL for chemical exam through a forwarding letter of SP along with an authority letter to break the seal in the hands of Yak Pathaise on 23rd. No, 23 তারিখে FSL পঠাই দিলে to have report to have report. No, I report to 86, no. Ahead. Yes, sir, your memo 23rd. Receipt to hold an up, taste take a pot has said. Barbarini taste take a person. How can you say that the responsible officer is perhaps it was with my I don't have. No, 24 তারিখে যে পঠাইছে ক'ত পা কৈছা তই এইটো
Received this office. Received in this office and. এইটো আকৌ চাওঁ নাই এইটো তোমাৰ এইটো মাৰ্ক কিয় আহিছে I couldn't understand this. There are two provisions in NDPS. One is 55 and one is 52A. 55 talks of taking samples.
NDPS Act.
So whether representative samples were sent for FSL or FSL, there are separate samples. I mean, I just talking about the law points. Lordship will see.
Please
second-
repeat your query. Please
whe-
repeat your query.
Whether, I mean, the question that I pose to myself is whether the samples which are made under 52A as representative samples were sent for FSL or samples which are made under 55 are sent for FSL. In my humble submission, I had always known as 55 samples were sent for FSL. Representatives were kept and the rest of the items were disposed of. Lordship will see 55. An officer in charge of police station shall take charge of and keep in safe custody, pending the orders of the magistrate, all articles seized under this act within the local area of that police station and which may be delivered to him and shall allow any officer who may accompany such articles to the police station or who may be deputed for the purpose to affix his seal to such articles or to take samples of and from them, and all samples should taken shall also be sealed with a seal of the OC of the police station. Violation of 52A.
Violation of 55.
Yes.
Violation of 50.
There's no seal, but SP is sealed with us. And 52A, Lordship will say this is totally representative samples which has to be done before the court. Well, and what's been? Go signature. 55 to 50. Lordship.
Perhaps you may be right. Since you posed the question to yourself and answered it, we need not bother. Correct. And you appear to be correct. The reason is that 53A, on reading it, we find that it is for disposal of the property.
Yes.
And it says that the central government having regard to the hazardous nature or vulnerability to theft,
Yes.
substitution,
Huh.
then may seek an order from the competent court, and the court, on consideration of the same, shall permit that as soon as possible.
Yes.
And then before disposal, you have to keep a sample of the
Yes. Huh.
same for preservation.
During
That's
trial-
what we understand. But we thank you as you put the question to yourself and answered it. We need not bother ourselves.
But then my
This is
learned
bail
friend
application.
used to say, he said,
My lord, once the contraband, 55 says the contraband has to be in the custody of the OC will affix his seal in the samples file. Now 53, 52A, that is preparing of the inventory. Now after the full bench judgment of Tufan Singh, my lord, now it has made mandatory because there was a contradiction between a standing order of 1/89, which says that the samples has to be drawn on the spot. And after the drawing of the samples, they will affix the seal of the officer in charge and they'll keep it in the Malkhana of the police station. Now, in the full bench judgment of Tufan Singh, it was held that no, since 52A says that the samples has to be drawn in the presence of the magistrate. Therefore, if there is a conflict between a administrative order and a provision in the act, then the act will prevail over the administrative order, and henceforth it was made mandatory that samples have to be drawn before the magistrate. Now, what they do, the present procedure, what they do is that NCP, the police they keep the sample, if the seizure is made in the wee hours of the night, when the CJM court is closed, they'll keep it in their Malkhana with a proper register, maintaining that at what time it was entered, who had entered it, it will be countersigned by the Malkhana in charge. The next day morning, they will take the contraband before the chief judicial magistrate. In the presence of the chief judicial magistrate, they will draw the samples. And in that samples, my lord, they may affix the seal of the chief judicial magistrate office, or they may affix the seal of the officer in charge also. In the NCB cases, your lordship will find that they affix the seal with NCB 1, NCB 2. The seals are marked, in that way, my lord. Then they will make a forwarding report. In that forwarding report, they will put a representative, they'll put a facsimile of that seal in the forwarding report itself. Now, when the FSL, when it is received in the FSL will testify that the samples were packed with a facsimile X, for example, with facsimile X, and this facsimile X also appears in the forwarding report. Now, during the course of the trial, that seal, that physical seal has to be produced before the court to connect the seal with which it was, the seal which was used in the police station or before the court, and the seal and the facsimile which is found by the FSL. That will, my lord, that will connect the seizure with the FSL report.
কিন্তু I'm not clear with এইটো নাপাওঁ মোৰ মতে FSL এইটো দি কৰিব লাগে এইটো ৰিপ্ৰেজেন্টেটিভ দুইটা বেলেগ বেলেগ হ'ব লাগে according to the act ইমানখিনি পঢ়া নাই representative as per act
But Mr. M. Biswas and counsel for the applicant, as well as Ms. S. Jahan and APP for the state, list on 6, 8 to 2024 for delivery of orders.
And why I have placed 55 and 52A is only to bring home the point that maybe, again, it is not very clear from the evidences. The samples that were sent to FSL were done through the SP's office. Therefore, it has the seal of OC, SP Morigaon, and that is a representative sample which had the CJM Morigaon seal. This is why I have placed a 52A and 55.
If that be so, then it is a clear violation of the rule.
Let's see that
That Mohanlal judgment I have to see.
you have to reserve something for the final final hearing.
Yes.
Correct.
Love that.
For hearing, item 4 to 7.
Better, it was heard by the bench of research, Michael and the Thomas. So in order, it was not reflected.
But if that is so, you'll have to move the honorable chief justice for assigning it to a particular bench, because we can't recuse ourselves unless there is an order indicating that it has been heard in part.
Mr. Lordship, kindly pass it over for the moment, Lordship. My senior is on his way. He's stuck in traffic.
This, in this case, this, there was a witness, list of witnesses, where is that? In the schedule, we'll have that list of witnesses.
Don't you prefer part one, volume one? Part one, volume one, it reflect the.
I just wanted to refresh my memory for one purpose.
Cylinder solution, product. Kidnapping and murder, lordship, for ransom, lordship. Part one, volume one. Consists of FIR, statement of witnesses and charge.
I just wanted to refresh my memory. I'll just give us 5 minutes time. Ms. Jahan, you remember a few days back, I told you that the British police uses a card, that pocketbook. Now look at this evidence. Mr. Chaudhary, you also see this. It's a unique piece of evidence. And here I'm trying to draw your attention for a reason that the state can adopt this. I've told it to your DGP, I've told it to your police, including your officers at Home Department, but look, read that. It's a re-examination, read it. Therefore, these people will not use the case diary to refresh their memory. It is a diary assigned to them. They have the unique numbers. It is their property. They keep it
Where they
lifetime
write
with
everything.
them. They make a pencil note of it and then they refresh their memory because of that.
While before
And that
they-
is why it starts from 195, this cross examination. And now you will find you read 195 onwards. Just have a cursory glance.
195 page.
Page 195 onwards, this is 6 page before that. Just have a glance. Now you will come to know about the procedures which is being followed when the samples are drawn, taken up, examined in the forensic lab. Just go through it.
Also, scope of 195, page number.
It should be 195 or 196. No. That last page which I gave you, no, it's 199. 190. From 196. And what I when I had no work at one point of time, then I was doing this. I was sitting there in the court, watching those proceedings.
CBI.
Huh?
CBI.
Just repeat. It's a huge, but look at the sequence in which things are going on.
It is nicely done. In most of the cases, these are not done at all. Neither did
That's why I said when I told you that let me refresh my memory, it's only because of that. Because once you know it, then only you can ask others to follow it.
Your Lordship, my senior counsel is, engaged counsel is on his.
Just a moment.
Meticulously, I saw everything is serial like.
That's why we are showing it to you. And this is something I told her a few days back. I think you were also there. So
About
this
diary.
is this I was referring to, and now I realize it is 10 years down the lane.
While deposing case diary is not required at all, the diary would.
I gave you a small lecture on this case diary. Give it to Mr. Das also. Let him, I don't know, senior counsel to come here, but page 196 onwards. No, just read the procedure, Mr. Das. Page 196 onwards. Just flip it. You will understand why I'm trying to show it to you. Mr. Dev Chaudhary is with you. He will tell you.
FSL क्यों बोले?
There the FSL was done in Yorkshire, no, I didn't get it. This is otherwise Putul murder case, but why was it done in Yorkshire? I failed to
He was
understand.
a citizen of UK,
Oh, acha.
and therefore when he was found murdered here, the police from there came because of their citizen was murdered. And so therefore they came here to investigate the matter. He received a call. And uh, I won't remember so much of details, but then they sent their scientific expert. He's a policeman with more than 30 years of experience in forensics. He comes here and does the forensic examination. And these bones, parts of the bodies that those were examined and tracked to identify the dead body. I won't remember so much after 12 years, 13 years now, I think 11.
11.
After 13 years, I won't remember the details, but at that point of time, and also read the re-examination.
That was it.
Hmm? No, it is in examination in chief. The re-examination is only with that diary. This is only to refresh our skills. Huh? No, actually, this is the first time I have I had the information. I was there. So
Very systematic and very. The last one, the pocket book, is that like log book that
correct.
and
Correct.
the vehicle is log taken out.
And one of the best presentations,
Or is it geriatric type?
one of the best presentations in CBI was the APP Lal
Yeah,
from Delhi.
yeah. What from the earlier one?
One of the best CBI advocate.
Yes. Yes.
Want an adjournment?
No, but my lord, with regards to item number 6, actually it was partly heard. May I proceed?
No, if it is not partly heard, I can't recuse myself. If there is an order, I can accept it, but if there is no order, we can't recuse. You'll have to move the Honorable Chief Justice and make a statement, because if it is assigned to us, we can't say no.
Your Lordship, I'm appearing for item number 7 on behalf of my senior counsel. Your Lordship, he's on his way, he will be a bit late, Your Lordship, he's stuck on traffic. So can you pass over the matter? Yes.
For the timing will pass over, let us,
There are 4 applicants, all advocates appearing on behalf of the applicants are different lordship. I think, Rukman Sharma, item number 6. He can start. Yeah, I can start.
we'll adjourn once Mr. Mishra is here, then we'll adjourn this matter. Because Mishra was a parted matter.
The lordship is well aware of this fact, this case.
I'm not aware. I'm absolutely not aware. I have no personal knowledge of this matter. To have personal knowledge of paper book of this size. Thank you for considering me as a genius. But I am not.
Fact of the case is that, who happens to be a, from the reading of the FIR, is a member of, Taklisina district, Silchar district, Silchar. He, was kidnapped by a group of extremists and, for ransom notice, subsequently was murdered. That was the fact. Initially, the case has been investigated by Assam police, and subsequently, after the direction of this honorable court, the whole case has been handed over to CBI also. And CBI, after investigation, found this accused person, charge-sheeted this accused person. The honorable trial court, after hearing all the parties' lordship, convicted all the accused person on the basis of confessional statement and other materials available on it. Start করা নেই।
Hello, may I proceed?
Right. Yes.
Starting from the FIR. Reflected at page number 1 to 4. But the operating part is at page number 12.
Your criminal appeal is criminal appeal number 50J.
I'm appearing on behalf of Roghan Sharma.
Your name,
My name Devashish
Devashish?
Nandi.
Yes.
FIR dated 18/3/2004. That is reflecting in page number 12. Whereas it is written as 1 to 4. Part 1, volume 1.
Volume. The number volume.
Part volume 1.
You continue. Please continue.
I'm reading the agenda. Humble submission is that at 9 a.m. yesterday, that is on 17/3/2004, my elder brother Sri Puton Dev, his driver Munia Lahar, and his Mohori clerk Jalaluddin left home for Bhairavi in my eldest brother's own vehicle in between 11:30 a.m. to 12 noon. Some young militants abducted the three from Bhaichara and left the vehicle by the side of the road, and therefore earnestly pray to your good sir to rescue my elder brother Pratul Dev, his driver Munia Lohar and Mohori Clark Jalaluddin from the clutches of the young militants and of them. This is the FIR, my lord, where they have stated alleging that Pratul Dev and driver Munia Lohar, Munia Lahakar, and Muhammad Jalaluddin, all of them were abducted by Riyang militants. Subsequently, the cases were handed over to the CBI after the investigation as alleged was not been properly conducted, for which CBI has taken over the case in page number 5 of paper book number 1. The operating part is at page number 7. Will I read, my lord?
Yes.
This case is registered in compliance with the order Honorable High Court Guwahati dated 12/4/2005, directing CBI to find out the culprits who are behind the alleged kidnap of Sri Putul Dev Roy, son of late Guru Prasad of Katlichera district, Hailakandi, Assam, passed in PIL number 48 of 2004, filed by the Assam Environment
Enviro Legal Protection Society and NGO of Dispute Guwahati seeking issuance of a direction for CBI investigation into Katlichera PS number 19 of 2004, which was registered on the complaint of Sri Anil Chandradev, brother of Sri Pratul Chandradev. Accordingly, the investigation of the said Katlichera PS has been taken over by RC number this, treating the said FIR number 19 of 4 of Katlichera PS as FIR of this case. The copy of the FIR of the Katlichera PS received from SP Hailakandi, Assam is enclosed, the translated version of which is as under. The translated version is that, sir, humble submission is that. in my-
Just a moment.
Yes.
Yes.
Yes, in the charge, in the FIR, made by the CBI later on, they are handed over to CBI. There also, they have stated with humble submission, sir, humble submission is there. My elder brother, Sri Putul Dev and his driver, Munia Lohar, along with his Mohurar, MD Jalaluddin, these three persons went out of the house yesterday at 17/3/2004 at around 9 AM towards Bhairavi in his car. At about 11:30 to 12 noon, some young aspirants had taken away from them from Bhaichara, leaving the car on the road. It is therefore prayed that my elder brother Sri Pratul Dev, Sri Munia Lohar and Mohru Jalaluddin may be rescued from the young extremists. My lord, here they have alleged that these three persons have been abducted by the Riyang militants, and later on, the charge sheet has been filed on 24/11/2005. That is at page number 1267. Volume. Madam, may I read the charge sheet?
Where is the charge sheet?
In volume, part 1, volume 5. Page number 1267.
Volume. Page number?
1267.
Page number?
1267, my lord.
Mr. Nandi and all others who were for the appellant as well as respondents. You see, from the volume of this matter, unless you prepare a chart, some presentation on chart wise to indicate number one, the witnesses examined, what point they have examined, and the exhibits which they have proved in a chart form, because this is we find it will not be in this presentation will not be able to handle it. The reason is there are how many accused? 6 accused, 7, 9 accused. In each of the accused, the questions are running to 600 plus questions, except for last accused. Almost every 313 statement is 600 plus questions. Almost there is a denial of the allegations. In most of them, there's no explanation given by any of the accused persons. So therefore, when the evidence is being examined, because of this volume, it will not be able, we will not be able to make a note and then what you call pigeonhole the information in our mind. Correct. So I would prefer that, rather we would prefer that you give a chart wise that which of the accused, what are the witnesses on which you are relying for the purpose of appeal, and this the evidence and the this document or pages wherever we are find it, so that in one page we can understand the entire gamut. That is one. You can prepare your own for the purpose of establishing your case. The second is gist of paragraphs on which you are relying. For example, the witnesses of 10 pages. In 10 pages, which particular page in which paragraph you are relying for the purpose of contradiction. But that is you're trying to only show a contradiction, saying that perhaps your argument would be that there is no eyewitness, number one. The second is that your linkage to the crime could not be made. That is basically your two grounds, which I can understand. But to rely on those paragraphs, since the 313 questions are 600 plus, unless you make that presentation, we will not be able to what you call understand the argument, because you understand our limitations. Just give me 2 minutes, we'll discuss with my brother if anything improvement can be done. So make that presentation, you indicate what are the contradictions you are trying to learn, paragraphs, so that it is easier for us, because if we start making notes, we will be lost in our notes.
My lord, I have prepared a note, but I'll make it, jot it down and.
You see, it's a chart-wise presentation. It should not be more than 1 or 2 pages. We don't want that long notes. If you want to prepare, do it. But for the purpose of presentation, make a chart-wise presentation so that in 1 page we can understand the witnesses, the paragraphs you are relying on. Don't elaborate in that page. in that first page chart, it's just like an index. Don't write a long note. For long note, you supplement it separately. But short wise, the paragraphs made the relied, the incrementing, most of the, I tried to have an overview of one of the witnesses. The incrementing materials which are available in the evidence is by and large appearing in 313 statement. So therefore, I don't think you can take a plea that in 313 statement there is any vagueness or the incrementing materials are not put before you. Correct. Although I have not read it completely, but on the overview of the matter, this is the first impression I am having. So, am I right? Then so make the chart-wise presentation, it will be easier for us, because if I start making notes, I'll be a lost person. We'll be lost in our own notes.
We have something they're relying upon.
We only want an index first.
Yes, yes.
Written notes you can do at your leisure. But written notes, which evidence, which witness, which are the relevant paragraphs you're relying on, the exhibits, what was exhibited what, and some indication of that part of the evidence which you had on which you are disputing. You can underline those exhibits and then so that we can concentrate on that. Correct. If you have a better presentation, please do it. But initial presentation is only 1 page or 2 page chart.
Index for each and every. So that how we want to proceed, whether you will also can get a.
No, not how you want to proceed, because we have told you, number one, you see, there are, let us say 10 witnesses. 10 witnesses are given a statement, and those statements are relied on by the trial court in particular paragraph of the judgment. So you can indicate those paragraphs where PW1 has been relied on. Contradictions, if any, in which paragraph you are indicating. So in 3 columns, these 3 parts will come. Then the documents which they have exhibited, exhibit 1, 2, 3, 4, those exhibits. And you can underline those exhibits or put it in a different color if you have some contradictions to show from those documents. You are questioning some document, some report, some examination. So please underline that so that in 1 page we can understand the appeal. There are 4 appeals, 4 appeals and 9 accused. So for that, you can make an accused as presentation, 9 pages of index. So it is easier for us. If you can improve in the what you call in this chart presentation, please do it. And then written notes will come later on when you complete your argument. We are not insisting on an advance written note. So how many days you want?
15 days, ma'am.
Mr. Haro, you have any other suggestions
Let it be on any Monday also.
on any Monday? No, suggestions on this presentation, first initial presentation.
The 9 acres is not necessary because appellates are only 4. On these 4 acres, I think will cover.
4 of us here are before your work.
Okay. Okay. When? Size the date.
As my is that for 19?
19th of February, okay. See, all sides are duly represented on a cursory note of the appeal, the 4 sets of appeal, we find that the documents are voluminous and the incriminating materials which appear against the appellants. Are from page 524 TO2 1165. Accordingly, the court is inclined to direct the learned counsel for the appellants to make an index of the witnesses, relevant paragraphs on which they are relying, contradictions in respect of uh, specific paragraphs of the contradiction of witnesses, and index of also containing index of exhibits on which reliance are being placed for enabling the court to appreciate the argument. Full stop. The chart presentation may not have a detailed write-up. Full stop. To enable the learned counsel for the appellants and the respondent to make the presentation, list on
It's an election petition. 20 February.
20 is election petition. Oh.
19 Continue.
No, 19th is an election matter. We're fixing it on 26th February then.
21 of the forest.
No, they want it on Monday,
No, 26.
then 26th. 26th February. Don't go by the order. If you can improve it, you do it.
Mr. Solan came to do. I think.
11 to 23, part third.
Mr. Mishra, before you begin, we'll take a break and come back. It's almost time to rise.
Compilation 3, yesterday was referring PW 39.
Yes, 39, compilation 3. You were last there. Huh?
So it starts with from paragraph 49. I I was to read the cross-examination. I'll place the cross-examination from page 15, compilation. Next. Our visits to Vietnam were sponsored by the central government project to attend Northeast India's Congress. I do admit that underground organizations who demanded money from our firm are unknown persons. I have no idea about their organization as well as their identity. There are so many unknown persons who are posing as underground elements and demanded in the name of underground organizations. I cannot say that any of the member of UNLF cadre demanded money from our family members as well as from our firm. It's not a fact that we never paid 30 to 40 lakhs per year to unlawful organizations. I do admit that S. Rakesh Singh invested as alleged. He himself says, alleged 60 lakhs to our firm as personal money and not related with UNLF organization. The said money invested by way of installment, piecemeal, according to the requirement of progress of contract works. The alleged seed amount of 17 lakhs was, I was saying yesterday. The alleged amount of 17 lakhs was encashed from the bank at Delhi. And the same was deposited to SP NIA Mr. S. Prakash Pani as directed by him. The money was not recovered from the possession of S. Rakesh. The said Caesar memo, Exhibit 87, was prepared in Delhi and I put my signature, that is Exhibit 87-1, without knowing the contents of the Caesar memo. I never said in the Caesar memo that Rakesh was an active member of UNLF to SPNI. I do not know the identity of the witness Kishan Lal. He never signed in my presence. The handwriting and signature contained in Exhibit 92. These are Kacha cash book. I will take the Rosh's. 92 is Kacha cash book. It says the handwriting and signature contained in Exhibit 92 were prepared at Delhi and the same was kindly masked, induced, instigated by NIA person in their custody and it was not given voluntarily. Exhibit 92 I have not given up put my signature and as such I have no idea about the alleged contents. I'm not aware of the contents of Exhibit 88 and further the Joint Secretary Dharmendra Sharma has any legal authority to pass orders dated 18/8/2008, that is Exhibit 88. It is true that I never went to appeal to competent authority against seizure of 70 lakhs as the money was not belonged to me. Exhibit 88 sent to me by the authority with a malice motive. The NIA officials was well known of the fact that money belongs to Rakesh. The copy of the order was endorsed to me wrongly. The said amount of money is due amount receivable by Rakesh Singh for his contract work. I just want to point out a few things. He says that 17 lakhs of money went into my part, his share, and it is deposited in the bank. I just ask a question to myself, whether the firm will not be required to show it in the account books from where they are getting it. Firm will be. But not even the other day, I remember, Mr. Khadonier, senior advocate, told me that he received a notice from Income Tax Office saying that what is the source of these fees? And same thing may not happen with Mr. Singhvi, the lawyer at this thing, in the Supreme Court. He was given notice. He had seen 91 lakhs. He had shown it at the fees. And where are the books of account? There is a books of account were eaten by the cockroach. So these are in paper. And there was a question also in the parliament. So small fees, they ask for source. This man says that Rakesh invested more than 1 crore. And that is all accounted for. If it is not accounted for, that's one thing. If it's accounted for. And he takes out 17 lakhs saying that it's my share. Then naturally, if he goes to appeal and income tax people comes to know about it, they will certainly say, where is the money? From where you got the money? You'll have to explain the source. And this should have been in the cross-examination, I admit. But perhaps the counsel appearing was himself may not be income tax paying, so he did not have this idea. But this should have been in the cross-examination. How you have shown this money in your accounts and why the account books were not produced? It's a question, I'm sorry, a question that I'm asking myself. No account book is produced. What is produced is kacha, cash book, which he says I've not signed. These are all instigated and induced by NIA. I'll place that exhibit 90. 91. My lord will take compilation 1.
Compilation 1.
Yes, compilation 1. First, I'll take your access to the Caesar memo. They have given different name, cash production memo. 87 at page 64 is compilation 1. On today, on 8/8/2011.
Where did I read it? I don't know, but I always, at many occasions, I have asked a question. You see, income from other source. Now, let us say A, who is a thief, he discloses in his income tax a sum of rupees X by way of theft, and he gives a tax. Now, you see, he has a books of accounts, he has disclosed it, he pays tax on it, but the question is whether that would become a legal income. The answer is obviously no. So therefore, once there is an admission of a transaction taking place, whether or not it is entered into the books of accounts, so far as he is concerned, he is bound by that.
Yes. Yes.
This statement itself.
Therefore, I'm saying this question should have been asked, and then his statement should have been sent straight to the income tax authority, because this form is also in Delhi and Manipur, and they would have asked from where, what is the source? Lordship will kindly come to 16. My lord, I have some agriculture income which I show. It comes within that heading, source from another, income from another source, and there we show. And for that, I had to, my lord, bring, in UP, they have Kisan Bahi. There is a Bahi note. So I had to book that, bring that book and file it with income tax. Just to show. I'll place 64, my lord, page 64 of compilation. Today on 18/8/2011, Robert Singh, who is presently residing at E49 ground floor, Greater Kailash, New Delhi, attended the office of National Investigating Agency, 4th floor, Splendor from so Delhi, voluntarily produced a total amount of 17 lakhs. In every action, there is voluntary here. Voluntarily produced 17 lakhs. Shri Robert Singh produced the aforesaid cash amount of 17 lakhs voluntary and in presence of two independent witnesses, so and so, so and so. And then I can skip, come to the next paragraph. The aforesaid cash amount of 17 lakhs, which was produced today by Robert Singh in presence of two witnesses, in balance amount of accused so and so, who is an active member of the United Liberation Front of Assam. Accused Rakesh had earlier invested 60 lakhs. These will not go in evidence at all. These will not go into evidence. In Caesar memo, you write source and all. So this is how, my lord, this was taken from the bank, 17 lakhs and given. So it's not correct to say that he produced cash. You directed him that you withdraw 17 lakhs. Could have seized the bank account. He could have seized, my lord, his account, books of account. From there, he would have come to know whether this money was actually. So taking cash of more than 1 crore is not easy for any. And that too in the keeping in the bank. It's impossible. It's against the law. Then, my lord, your lordship will kindly see now 66, page 66. I'm just passing reference. This is, my lord, a letter order which was given by designated authority, joint secretary, informing Mr. Robert here that the second paragraph I read, whereas I therefore designated authority under section 21E of the Unlawful Activity Prevention Act 1967 as amended in 2008, after satisfying myself that the aforementioned Caesar is part of the resources of terrorist organization, UNLF, in pursuance with the power vested with me under section so and so of Unlawful Activity Act as amended, hereby ordered retention of the Caesar cash so and so. Whereas under 25(6) Unlawful Activity Prevention Act, the said aggrieved party is entitled to an appeal under National Investigating Agency, Special Court, Guwahati, within a period of 30 days. I was in custody. If it was my money, it should have come to me. Why should it go to Robert Singh? Therefore, Robert Singh in his cross-examination stated this was malice, with malice, it was sent to me. They are blowing hot and cold together. They said this is my money and they are issuing notice to PW39. Now the next page your lordship will see Exhibit 91.
Who was PW 39?
Robert Singh, the person in whose this thing I supposed to have invested in 1 lakh something, 1,10,000. I've just read out the cross-examination with it.
Oh, acha. Okay.
That person.
Okay. So if the money belongs to, you are saying that money belongs to you,
Yes.
notice under 25(6) should have been given to you.
Given, why does not be? So that is why he has very clearly said in the exam, it is a modified. I have no knowledge.
UAPA, Unlawful Activities Act. Is this? This two? Oh, yes.
Is it a 13 edition?
Unlawful activities. This is 22.
See, your lordship will see this compilation two. There are amendments. Or I can.
No, this 6 is, there's no amendment in 6.
Otherwise, this.
In 6, I believe there is no amendment. Ju- Okay. Because this does not have those marks.
This is 2013 edition. It will be right. Not 13 again.
It's okay. There's no change.
Now, your lordship will kindly turn to 67.
Just a moment. Let's see. से बिल करा करने The seizure is found to be illegal. The retention order of retention is illegal. The order of retention becomes illegal, I think.
It becomes illegal. It's actually.
No, because of different reason, not because of that. You come to order this section 25, 5.
Yes, the investigating officer may seize and detain any kind to which this chapter applies if he has reasonable ground for suspecting.
So A, B, you omit, now proviso.
provided that cat feed under these sections by investigation shall be released within a period of 48 hours, beginning with the time when the seizure, unless the matter involved in cash before the designated authority, and such seizure passes an order allowing its retention beyond 48 hours. So that is
So
how,
that means this must be prior to 48, expiry of 48 hours, not post. This order is passed at page 66 on 18th.
that is.
So
only-
that is beyond 48 hours. So it will be illegal.
I did not. Yes, well, 10 days.
No, that's what I'm saying. 8 to 18 is 10 days, so beyond 48 hours.
Yes. 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 And plus your occupancy, if there is my money, notice should come to me within
But
48
then
hours. Why it has gone to Robert? I don't know.
Answer is very simple. When I was young and in the college days, there was there used to be a villain in a movie whose assistant was always a Robert.
Yes, very probably. Philip Robert Das. My lord, kindly come to page 67. 67 is exhibit 91. Page? Page? Page 67. So the body law, next page, 67. This is exhibit 91.
Yes.
So this has been exhibited. What is written there? Then next page your lordship will see. This is 91, the next page is 92. And I don't know what is, if it is original Kacha receipt, then how come this is typed, or they may have taken photocopy and pasted this? Maybe, but then it will not be on this.
No, it is pasted because that mark is there.
Yeah, that they have, right?
Hmm.
That's what I'm saying. It is not the original papers which they have seized.
No, this is original.
Yes.
It's pasted in it pasted in that memo.
And this, what one says, the handwriting and signature contained in exhibit 92, I'm reading the PW 39's cross, were also prepared in Delhi, and the same was induced and instigated by NIA. He has said about it at page 267.
267.
Page 51.
51 of compilation 2, 3.
Yes. What's the middle? Ninth line,
51.
51. Ninth line from top.
The handwriting and signature contained in exhibit 92 is prepared in Delhi.
And same was induced, instigated by NIA person.
Oh.
So that is saying about this exhibit.
the-
Then next 69 your lordship will see.
Yes.
The next page, 69. There is 92. Continuation. Your lordship will see what is received here, written here. 16/10/2009. By cash received from Rakesh through Robert. I don't know the meaning. It's all manufactured document. Received from Rakesh through Robert. Then by cash repayment to Rakesh. Sir, I don't know whether I will not correct. Run by Robert. Then your lordship will see specifically one entry, which makes everything false. 19/8/2010 at the same page. 19/8. They're showing my lord 1 lakh. I don't know to whom they are paying, but they are showing if it is Rakesh. Then Rakesh was arrested the next day, 19/8. 28. He was arrested. And produced and sent to judicial custody. From his person, they did not get anything. All that I'm saying, this Kacha, Vidyacharan Shukla, your lordship will remember. CBI versus Vidyacharan Shukla. This is not even a regular account maintained in accordance with section 34 of the Evidence Act. Some here, there, something they have written. These are all manufactured documents.
You should be thankful they saved you from a narco analysis test. You gave a voluntary statement, saved you. You were saved.
Yeah.
Otherwise, narco analysis test would have revealed this same thing.
Even if it reveals, Sylvie case is very clear, Sylvia. That will not go in evidence. Will not go in evidence. Therefore, exhibit 91 and 92 is nothing, my lord, cannot be read into the evidence. Yes, localization, compilation. Now, my lord, sorry. The question that I asked myself, why did Robert give this statement that I have invested so much money and at the same time says it's my personal money and not of UNLF? He says both things. He says, I have invested in cash, but it doesn't belong to, it's my personal money and it is nothing to do with UNLF. He has made this statement. Why did he say this? The only answer that comes to me is, there is an admission that he is paying 30 to 40 lakhs to underground every year. He has said in his brief. That's enough. They must have said, I'll put you under section 17. You are financing. And therefore he has said, but he had the courage to come and tell in the court that these are manufactured. The 91 and 92 were forced at the instigation of NIA, these were made. Since he has the courage to say. Otherwise, NIA has completely concealed that this amount of 17,000 was taken out from the bank. PW19 said they forced me to take out from the bank as per dictate, and I took out from the bank and handed over to SP Pani, the CIO. Therefore, the investigation is full of flaws.
Just a minute. Mr. Prasad, you prepare index of this volume so that easier for us to find out. Just compile this, make a photocopy of this. You photocopy of the index and give it to us. Because it's easier for us to find out then. Bye. Yeah, yeah. Mr. Mishra, because of your argument, I just thought it to cross check. At page 703, I'll pass this. You don't have to.
So I have
Huh.
supplementary.
Huh. This volume 4. Volume 4. Volume 4, page
This one.
703. No, this part 1, volume 4.
Page 70.
700. 703.
70.
Mr.
Yeah.
Question 19 is PW 39. That is not considered to be incrementing material by the court. 313, you are not put that question. So therefore,
That question has not come.
therefore, this is not considered by the trial court to be an incrementing material. So therefore, if you have if you are convicted because of that, then it may be pointed out to us because
So, but as far as the examination 313 is concerned, wherever I have appeared, I have seen Similar questions, one question will be prepared and give it to, give it to.
No,
the-
that's something else, but I'm trying to evaluate your argument with vis-a-vis this 313, and therefore if it is not there as an increment material,
Yes,
I-
yes, your lordship is absolutely correct. Anything incriminating, the will have to be put to me. That's the purpose of 313.
therefore otherwise also 92, 93, that's not a part of the evidence against you. This is something you'll have to answer, Mr. Das. You got the query?
Now, last in this 18 and 121. A. Hello, besides section 20, which has taken so much time. The appellant was also punished under section 18 and section 121 A IPC, 18 of UA and section 121 IPC. Well, the under section 18 UAP, the appellant and others were given, my lord, 8 years RI. That your lordship will get in paragraph 98 at page 994 of volume 5.
Part 1 or part 2?
Part 1.
Part 1.
Part 1. Lexicon. Volume 5, my lord, part 1, volume 5, at page 994. Paragraph 98.
Became wiser. We became wiser in this matter, and therefore in the earlier matter, I told that to make a chart-wise presentation so that I can understand where is where. The 313 statement is running into 640, 50 questions. So very difficult to pigeonhole in the mind.
Section 18 is 8 years and fine of 10,000 in default 1 year. Paragraph 98.
So he was convicted under section 21 also.
Yeah, that'll come.
Huh.
First 1898. So just in 2 lines, 2 sentences, 2-line sentences, they were convicted as a both the sections. 18, he is given 8 years and fine of 10,000 in default 1 year. And 121A, he has been given 10 years. 10 years. Fine of group is 10,000. In default 2 years. I'll place the sections, my lord, which your lordship will get at page compilation 2. UAP,
Under 121A, 10 years.
10 years. And in default, 2 years. For 2 years.
Just a moment. I'm repeating it. Section 20, 7 years he got.
Section 20, he got 7 years.
18 he got 8 years. And 121,
10 years.
10 years. Three sentence. Yes.
I'll place section 18.
18.
Section 18. You can see how we do also. Otherwise, there's amendments are there, but these are correctly mentioned. Otherwise, compilation 2, I have an extra. At page 12. Section 18.
Yes.
Punishment for conspiracy, etc. Whoever conspires or attempt to commit or advocates, abates, advises, or incites, directs, or knowingly facilitates the commission of a terrorist act or any act preparatory to the commission of terrorist act shall be punished with imprisonment for a term which shall not be less than 5 years, but which may extend to the imprisonment for life and shall also be done. Now, my lord, the provision itself required that some act is to be committed. Some act must be committed, which is in the nature of preparatory to commission of a terrorist. What the trial court has done, he has verbatim lifted it and placed in his judgment while holding me guilty, that he has committed an act which is in the nature of any act preparatory to the commission of. What act? Nowhere he says. Now, suppose my lord, in an act preparatory to commission of terrorist act. So I am making a bomb. In my house, the police comes, raids, and I'm caught. They will interrogate me and then I will say that this was for this particular terrorist act, or we were going to commit a terrorist act, may not be specific, but we are going to commit this terrorist act in the town. So there is something, some act, like I'm making bomb. Some act is there, which is in the nature of preparatory. Naturally, before I blast somewhere, I have to prepare a bomb or I have to import a bomb. So those, some act has to be there. Without that, it is not possible to say. Then we will, I will say 181, 121A, because it is just 2 lines separates and he is punished. 121, if your lordship will see IPC and not the next name, IPC if your lordship can take.
Conspiracy.
121, article A.
CIPC. IPC.
Conspiracy to commit offense punishable under section 121. Whoever within or without India conspires to commit any offense punishable under 121 or conspires to overthrow by means of criminal force or show of criminal force, the central government or any state government can be punished with imprisonment for life or with imprisonment for either description, which may extend to 10 years. So the conspiracy will have to be proved. Conspiracy, your lordship knows, not possible to have direct evidence of the conspiracy unless we have a compliance. But there should be circumstances, there should be meeting of mind. These are the requirements, they must be proved by the law.
Not under section 8. That's why on the first day I asked you that question.
Huh.
Section 8 of the Evidence Act.
Yes.
Because it says that there may not be a meeting of mind.
Yes.
One may not know the other.
No, meeting of mind is different. One may not know the other. One may not even know what step is going to be taken.
Yes.
But meeting of mind is a must, with all respect. Meeting of mind is a must.
No, you see the examples in 121, sorry, this 8,
What?
the section 8 Evidence Act.
Yes, yes. Both
You-
preparation and previous and subsequent.
You see the example, illustration.
Yes. Which one you got together?
Oh, sorry, it is 10, 10.
Yeah.
10, not 8. Yeah, I'm sorry. It will be 10. Illustration 2. The facts that we procured arms in Europe.
Yes. Europe, for the purpose of conspiracy, C collects money at Calcutta, like any object. D persuaded a person to join conspiracy in Bombay. From Delhi, joint conspiracy at Bombay. E published writing advocating the object at Agra, and F transmitting for Delhi or G to Kabul the money which C collected from Calcutta, and the contents of the letter written by H giving an account of conspiracy are each relevant. It's a different one. may
Both,
not
no,
know it.
both to prove the existence of conspiracy
Yes.
and to prove a complicity in it, although he may have been ignorant of all of them. And though the persons by whom they were done were strangers to him, and although they may have taken place before he joined the conspiracy or after he left it.
So there are various stages of conspiracy.
So that's what we are saying, that
And-
here, if it is under section 10, then meeting of mind is not necessary. You do an act independent of each other, not knowing each other, the connectivity to each other, but still it is
So
conspiracy.
meeting- So what is meeting his mind is, it's not physical meeting. As a conspirator, I know that I have to reach Bob and give it to Mr. Dal. What he does with it, I don't know.
No, even that is not necessary.
That's
Because in
right.
conspiracy,
He
what
does,
would
I
be?
don't know.
No, even delivery to X is not necessary, because what would do is that a bomb is prepared, you place it at place X. So he places it, it places X and goes. Then,
He's so naive that he will place a bomb at one place and he will not know anything.
no, because that's why you see, the advantage of looking at movies of James Bond is only that. You see, certain thing is left at one place and he goes, the other one comes from that place and goes.
That's right.
So therefore, what happens is
Now-
that he is not supposed to know that who is the second man who will be carrying this.
On meeting of mind, there are decisions which have it definitely place. Your Lordship, kindly see, in case of conspiracy, direct evidence, Your Lordship agree will not be possible unless there is an accomplice. How do one prove the conspiracy? Conspiracy will have to be proved somehow by
No, let us say
circumstantial
that,
evidence.
let us say that we take an example of UNLF.
Yes.
UNLF has has say under Commander 1,
Yes.
there are 3 more commanders,
Yes.
assistant commanders, let us say.
Yes.
And what happens is that the one says, you please collect money.
Yes.
He is collecting money. You give it to A.
Yes.
He gives the money to A. B has to procure certain things and give it to X. He does it. So this is how things are done. And then what happens is that somebody comes and collects it. You give that ransom letter is prepared by one, kept at a place. From that place, a boy, what you call a minor, takes up the letter, gives it to the person on whom ransom is demanded. And so you see, the conspiracy can be without each one knowing what the other is doing.
How do we infer the conspiracy?
I don't know, because section 10 shows that if a conspiracy is a waging war of India, if 5 parameters can be brought in and said,
That is, say, object. Object is waging war against the.
yes, so if five
That's
people,
an object. Now, we have to do our part. Somebody will have to say, some say boss. He says, you put this there, you put this there, he will come, he will collect, he will give it to him, he will, all these. So there has to be a chain.
yes, chain has to be there.
And then chain only will bind the circumstances. So there has to be circumstantial evidence.
Look up to it, because section 10 is, I find is interesting, because this is some ways.
I'll definitely try to on that, section 10. But then if section 10 is there, then there nothing is required to be proved, only section, there is a conspiracy.
No,
Whether-
chain of events. Chain must be there, yes, but this, we have to,
Yes, yes,
we are glad that you are here, we'll learn something.
yes. Anyway, those things will not, may not be necessary for this case. Because the judge himself says, there is no proof of meeting of mind, there is no conspiracy. After that, how can he say that there is conspiracy? So it will not, may not be necessary for this. That's why I have not seen, that he himself did not see.
Continue at 2.
I got a judgment where it says meeting of mind in necessary, just 2021.
Is it?
That is by Justice R. Sudarshan Reddy and our own Justice Rishikeshwar. He'll be sending that, meanwhile I'll proceed.
You can get just a citation, I don't need it.
2021. Supreme Court.
2021 Supreme SC 801.
That will be paragraph 12, I don't know that one.
I get it.
Paragraph 12.
Para 12.
It's got 120. Only as so.
Yes.
Only as Sonu versus State of Haryana.
Oh, Sonu. Yes.
No, no, bhai. On this, I will not take much time. I will take your worship straight to paragraph 85 of this. Right, judgment.
It's volume 5.
Yes.
Page.
990.
Para
Paragraph 85.
85.
Page 990. Well, I have not found any other place discussion about these two sections, 18 and 21. There was, however, I'm placing 85. There was, however, you reading something?
Yes.
Should I place? 85 I'm placing. There was, however, enough evidence to prove beyond reasonable doubt, as discussed in paragraph 27, 46, 56 to 61, 62, 63, 65, 66, these are all emails of the judgment, that some of the accused persons, namely A6, this pilot, I'll be referring when I argue accused number 8 and 11. Same, therefore, your lordship will mark here A6, then A8 and A11. These are the three appeals filed by these accused, which I 6 I'm doing. I have to do 8 and 11. So some of the accused, namely A6, A7, A8, A10, A11, A12, also, were conspiring or attempting to commit an act. What act? The single judge has not said. Which was in the nature of any act. This is unprecedented. You may not find any judgment like this. That they were conspiracy, they were conspiring or attempting to commit an act which was in the nature of any act preparatory to the commission of terrorist act. Which act? Any act. And we are also conspiring to commit an act which is punishable with section 21 of the IPC. There was, however, no specific evidence of waging war or attempting to waging war against government of India. The act was limited to the extent of conspiracy to wage war against government of India. Before it reaches the stage of even an attempt to wage war, they were detained and brought forth to face trial. Accused number so-and-so are held guilty under section 18 as well as and section 121A. This is the entire finding about 21, 18 and 21A. Not which evidence, which PWs, which document you have relied, nothing is there. Any act. conspiring to commit an act which was in the nature of any act, I fail to understand. My Lord friend will certainly explain to your Lordship. Then my Lord will kindly come to 86. 86.
But in this para 85,
Yes.
the trial court in shortcut has said these were discussed in para 26, 46, 56.
I'll place those paragraphs. Your Lordship will see. Paragraph 27, Your Lordship will see. At page 961. Twenty-seven is at page 961. PW 21 deposed that sometime in 2010, police arrested A5, A6, A7, A12 from his residence. From his house, A5, A12 was staying in a room rented by him, and A6 used to stay with A12. The father stated that video seizure memo so and so, white seizure memo number so and so, police seized several items, a large amount of cash amounting to more than 2 lakh. They are not concerned with this. So this is about arrest in Guwahati. Then the next trial judge has referred to 46. Your Lordship will turn to
So
46.
in 27, all we have to see is now the exhibit 46 and 47.
Yes, that doesn't concern me. It's not recovered from me. I mean, I know any of the case.
Not recovered from you.
46. Exhibit. Exhibit 46 is at page 191. Very good, very nice. Yes, 191 of part 2, volume 1.
Part 2, volume 1.
Yes, this is recovered from A12.
Exhibit 46,
Page 191.
191.
Yes, on the top it is written page number 1 of 10. Below that, exhibit 46. On top left hand side.
191.
Then next is
Ah,
47,
I've seen that.
page 7.
191 and 193.
Then, my lord, we will go 56 to 61.
Fifty paragraph.
61. Page 7975. This does not concern because this is by protected witnesses PW3 and 4. They are the journalists, my lord, who claim to have gone to across the border where the UNLF camp was, and then they have made some recording, and then they have stated that we are not concerned. None of the accused whom I am representing are concerned with this. 56 to 61. Six to 61, I'm not concerned. Then 62 at page 797 and 979. Sixty-two is concerned with accused number 7 and accused number 16. This is the evidence of PW7.
Yes.
62 does not concern me. 62 concerns PW accused number 7 and 16. So this do not concern me. The statement of PW7 I just went through. And then I remember somewhere I have read evidence of peeping Tom. This PW7 said to have overheard them talking inside the room and he deposed and accepted.
Walls have ears.
My lord, yes,
Is old saying, walls have ears.
have years not for the purpose of proving something beyond reasonable doubt. It is for drawing room gossip. So 62, I'm not concerned. Now,
I
then-
don't know, I'm an ardent fan of James Bond. Never watched any of his movies, so
They have lot of bugging device. They put it, they hear and they investigate. They investigate. Then my lord will see, the next, he says 62, 63 and 65. So I have placed 62, it doesn't concern me. Now 63, my lord will see. 63. Yes, 63 also does not concern me because it is the evidence of that peeping Tom, PW7. On the right hand side, 981, toward 6 lines from the top, your lordship will see A7, A16, A18 and A20. 6, 7 lines from top of 981. This doesn't concern me. Rashi Bhattina.
para 63 is interesting.
Huh?
Para 63 is interesting.
Hey, he saw that this is where he is. Oh, it's eavesdropping. He heard something.
He heard talking in English, they were talking about purchase of so and so from military training in China. He became shocked, ran back to his hotel, next day left for China.
That's what she says. This is the kind of evidence they have. That's why I said, I think somewhere in Punjab, I'm not for them, but in Punjab, there is a thing, the peeping, so settle all that evidence of peeping Tom has to be strictly rejected. And therefore, you will accept.
And ran to China. The best part is he ran to China.
He left China. He left China.
No, he is the person who is involved in sending students for MBBS and other course. And he used to go there. I'm not concerned, I don't want to go.
He left China for India via Bangkok.
Then, my lord, 63 over, now 65 and 66. So 65. Learned Defense Council argued about testimony of PW7. So 7 we are not concerned again. 66 is also 7. Because this is, the trial court got overwhelmed by their RPG was there, the China, something is going on. He stopped and he was convinced. Nothing against A6, A8, A11 or A15. And 24 of course is different. Then nothing. So this is gone. All. So that address 85. 86 will be very interesting.
85.
85. But 86 your lordship will say, trial judge said there is no conspiracy. Where do, I mean, I don't know where to stand. 86 is just below 85 at page 990.
85.
Just below 85.
No, 86. Okay.
86. In regard to charge under 120B IPC, the established law is mere knowledge of a plan or objective or discussion per se is not enough to prove charge against all the accused persons. Who might have merely known about the plan objective. Since all the accused are held to be members of UNLF, it may be presumed that they might be aware of the main objective of the organization, which was to attain independence of Manipur from state of India. But that is not enough for proving charge of criminal conspiracy. Very emphatic. Meeting of mind is most essential ingredient in the criminal conspiracy. Surely there cannot be direct evidence of meeting of minds of all the accused, but there should be some circumstances to positively indicate that there was a broad agreement among all the accused to commit an illegal act or a legal act in illegal manner. Then he refers to Ishar Singh versus State of AP. I will skip this quotation portion. Then I said, but in this case, there was no such kind of, but in this case, there was no such circumstance in as much as no commission of terrorist act within the meaning of section 15 or any act or attempt to wage war against the government of India could be proved by the prosecution. And therefore all acquitted under 120 IPC. I fail to understand because I have little knowledge about my knowledge is rather very hazy. Section 120B has 2 clauses, if I remember correctly. Punishment in one will be proportionate to the act committed pursuant to the conspiracy. The second is independent of it. And that is 6 months or something. I don't know which act was referred to him, read which on 120B. Nothing is clear. Now, therefore, my lord, I'll sum up the entire first.
Mr. Mishra. No, have you what? You see, we both have a query. If 120B goes, how does it affect 121A?
Answer to that will be in the shape of a question only, which will be to me. Can there be different set of conspiracy for 121 when there is an emphatic finding?
That's what we are asking you.
Yes,
That's why.
there is an emphatic finding that there is no conspiracy. So it cannot be said that there is no conspiracy under 120B, but there is a conspiracy under 121A. And it must be based on evidence. Where is the evidence?
Let's come to both the provisions
Yes.
because we are not very clear on,
Yes, yes,
after this finding on 120B, we are not.
yes. Yes, the lordship, first we will read 120B, okay, 120B. Whoever is the
Well,
party
First
to
of all, 120A, okay, definition.
120A we go. Conspiracy to commit offense punishable under 121. 121 is waging.
No, 120 capital A,
Yes,
it says definition.
Yes.
Definition is an illegal act or an act which is not illegal by
Yes.
legal means.
Yes.
Such agreement is designed, there is a criminal, no agreement, so and so shall amount to some act is done by one or more parties. To such agreement pursuits thereof, it is immediately whether illegal act is the ultimate object.
conspiracy is a conspiracy, whether it is done for commission of 121A or other offenses. And can we see 120B1, as I have said, and then 120B2 is punishable not exceeding 6 months.
Because you see, if, I'm just trying to understand, if 120B goes, how does it affect or interlinked with section 34 IPC? 34 IPC is acts done by several persons in furtherance of common intention. So if a criminal act is done by several persons in furtherance of a common intention of all, each of such person is liable for that act in the same manner as it was done by him alone.
34 and section 149 are similar, except that under 149 it will be more than 5. And under 34 it has to be 5. Your lordship must have seen conversion from 34 to 149. If it is found that there are 6 persons, you can't convict under 34, so they have to be convicted under 49. But it's not conspiracy, it's an intention. So they form intention to do something. And in 149, it will be common object. 34 is common intention. In latest, some decision I have seen that now they are questioning whether 34 can be converted into 148, 149, because the common object and common intention are two things. Because each and every member of unlawful assembly will be held responsible under section 149, whether there is any overt act on his part or not.
There is also one of the discussions, Law Commission recommending damage to public property
Yes.
should be realized from the persons.
Yes, once the, otherwise also, in our country, we don't do it. Elsewhere, any criminal act gives rise to two liabilities. One is, he will be punished for what he has done under the penal law. Second, he is liable for the destruction of property which he has done. He can't get away. So civil suits are fine. In our country, this is not there. So perhaps Law Commission is addressing that issue. Because nobody goes. Malicious prosecution, who goes? Mohit Hojai was in jail for 14 years. For nothing. When the court took up the matter, I said there is no evidence. And some uncharitable comments were given, it is recorded. That in Rajasthan, what, head constable will do a better job. These are the comments which came. I'm not on that, but I'm saying that the investigation has to be done properly. But if it is not there, it is not done, then merely because the charge sheet is submitted, that is of no consequence. Now, my lord, just one paragraph I will, because I could not place, paragraph 52. At page 974. To say all the emails attachment retrieved on voluntary disclosure of email ID and password by accused 18 and 19 reveal activity of UNLF, its members, some of whom are accused as discussed in the earlier paragraphs. It was clear from emails and attachment mentioned above that the accused 5 to 18 were involved with UNLF as a member of the organization. And it was clear that A19 was chairman of UNLF. So the entire finding that accused persons were member of the UNLF is based on emails, which are not admissible, as I have said. And I've also referred to the emails, particular emails in respect of AC, and then I submitted that it's of no consequence. So paragraph 52 is only based on emails. So my lord, I will sum up this accused number 6. Number one, there is no evidence against him, except the one that I have said, emails. Email 115 series, which was exhibited by 53, not the contents, but just he said it is signed by me, it is signed by me. But there is no, the certificate which is given by PWP does not certify, is totally silent rather on the email, computer printer. There is not even a whisper on that. Therefore, in absence of the certificate, all the emails will have to be discarded. So this goes. Even if suppose for any reason your lordship says, okay, I will look into the emails. The emails that, my lord, your lordship, I have placed before your lordship are exhibit 115, 51, 52. It says he will jump bail, he granted bail. Nobody proved whether I am the same Rakesh who is being mentioned. Nothing is there. So there is no evidence. Now PW, my lord, 9, 17, and 39. They themselves say we don't know that he is a member. We cannot say. But so far our knowledge goes, he has not committed any crime. 39 says he has invested some money, but I have given your lordship his cross-examination where he says that everything was managed by NIA, including, my lord, the recovery of 17 lakhs, seizure, and then how they are trying to substantiate by kacha copy, 91 and 92. So in my humble submission, there is not even an iota of evidence to punish accused number 6 and the appellant in this very case. And I will pray that he may be acquitted. I have half an hour, I'll finish, but I want to finish. Now, item, my lord. My lord, now I will place my lord, today's list, serial number 15, rate appeal 264 of 206. It will be almost covered by 6 by my argument in
Criminal appeal,
criminal appeal 264 of 2016.
Sinam Gume Singh,
No, Oina Monitor,
264.
264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264. 264
हाँ वही ना
Money.
Manitron Singh हाँ.
Money. All the student, my lord, A6 was a student leader, he is a student leader. Now, my lord, here in his case, he has been convicted only under section 20. To undergo 7 years RI, pay a fine of rupees 10,000 in default 1 year. On his own. He has not been convicted under 18, 121A or any other section, only 120, section 20 of UAP. My lord, kindly see the charge. Charge at page. Yes. Charge दोनों पहले.
Just a moment.
Four कहाँ है? Four है ना? क्या दे रहा है उसको? Four है? Kindly come to page 34. Earlier, I was referring from, my lord, the paper book that we made this was included on. Page 31. Page 31.
This time you are miserly, you have scaled down the size of paper book.
They won't keep it. In fact, I find it difficult to read even if the letters are small. But indeed it's. Page 31, your lordship.
31, yes.
Now, the appellant before your lordship is at serial number 11. Oina, Monitron 6, A50. And since he has been convicted only under section 20, I'll take your lordship to section 20 at page 33.
Yes.
33, that you being member of terrorist organization involved in a terrorist act as mentioned in the foregoing head of charge, fifth head, they repeated already applicable. Thereby committed offense under section 20 of. So this is the charge against the applicant, accused number 50.
Accused number?
50.
But this Oinam Monitron is A7, I believe.
No. He is A50.
Oh, acha, Oinam, oh, serial number 11. Okay. Oh. Yes.
Evidence against him, so-called evidence against him, are only emails. No oral evidence has been laid against him.
No relevant, only,
oral
only email.
Only. Now, emails, well, I have already said, and emails of 115 series and its attachment. And I have already argued in detail why these emails are not admissible in evidence, so that argument will stand in this issue. Now, to be on the safe side, I'll take your lordship through 3 emails which have been relied on. Those emails, if your lordship can have combination number 1. All the 3 emails are given. The first is at page 75. That is email 115/13. Please note at page 75. This E4/2, which is the document number. So it's not exhibit.
Page 425, sorry, 75,
425 is the
internal number, huh?
75 is, I'll read. Because exhibits are below this one. We don't know which exhibit. These are below. So I'll place 113 if it is same. This is to DK Enterprise from, we don't know, there was something. It is necessary to look in information given by Tanali about money too. The date, so I'll give the content. My daughter and his husband expressed suspicion to Monito regarding the arrest of our men recently from Hot Place, Guwahati. Monito knows most of our men. He is also opportunist, as told by them. They expressed their desire to keenly observe Monito. They also told me that Sri Tikan is associated with him very closely. In the meantime, during their recent arrest, his name was not coming out in the local Delhi. My ID for us is so and so. Then the second one, Oja, father-in-law of Mani, said something when I sent mail regarding arrest of Mani, told to ask about that only. Oja sent no reply to my mail. I know that his ID is not used only after I received mail from you, sir. Till date, no specific information regarding their arrest is received. Ingmar told that Indian currency of 3.4 lakhs and 2 laptops were seized along with them. We need to take more information regarding Monito. The family is trying to release him. We take help from party when necessary. This wording has one underlying idea about this. I told so. Now, I don't know whether this speech whose money. Very important. Now, this doesn't take us anything. It's not a proof of anything according to my conviction. Which money tone? Nothing is, nobody has proved the contents. No one has proved the contents. Then the 2 emails, then the next email is at page 81. This is the email between some port and green plate. I'm sending the account of for July. Reports from DS should be sent tomorrow. Reports are there which DCO could not send. with accounts in some court, correction is necessary. Regarding education, I told you, I conveyed the same to two advisors and president when they were together mentioning the past and the future. It is true that so-and-so does not go. It has knowledge to advisor. This is due to lack of the permission. This duty was interested to hear reply of explanation what it then agreed to people. I don't know how this is. This is very. So, in my humble submission, my lord, the first is that these emails will not go into evidence, will not be ready to evidence. And third is for any reason, if your lordship want to read into it, it doesn't make any sense. So what evidence, whether it can be treated at all as an evidence, because nobody has proof. Somebody writes, like I gave yesterday example, A writes to B, let's see, has committed murder. That not be a proof, it has to be proof. So these are the evidence against him. Therefore, my submission would be that since only email have been relied upon, which are also not, doesn't prove anything, these emails are not admissible in evidence. Therefore, my submission would be there's no evidence against him. Yeah. Then next is, my lord, I'll go to 14. 263, 2120 of 2016. Gunet Singh, Sianam Gunet Singh. He's accused number 11.
Criminal appeal number 263.
263, 2016.
Sinam Gume Singh.
Gunet Singh. Yes, Gunet Singh. He has been convicted by like A6. He has been convicted under 2018 and 121A. Under section 20, 7 years, same as accused number 6. And in his case, no oral evidence. It's all exhibits, that email 115 series email and attachments. Your lordship, I'll take your charge, similar charge I have read it out to your lordship, all similar at page 31. Then I will, my lord, take your lordships to compilation 1, the email which have been relied upon. The first email relied upon is at page 77, exhibit 115 of 51. My lord, here also not admissible, these emails are my contention, like I have said in accused number 6. Similar contention will be there. The first email is, my lord, 115/51 at page 77. I have already placed before your lordship where it says that Londani Rakesh jumped bail. The other says Londani and Rakesh jumped bail at page 77. Yes. Then the next is page 78. Page 78. In Guwahati News, 11 person, including 2 ladies, were arrested. 5 laptops, 20 handsets were recovered. According to the news released by them, the following person were arrested. And then the name is there. At serial number 4, S. Rajesh, Prem, Londhoni, so and so Noren, W. Noren. The name of other person is not known. Prem is there by doing tailoring. He stayed together with Nagamba. Naresh is Khaden. No. I have 2 reasons to suspect regarding the incident. First, Londhoni came by yesterday evening flight. They knew by following her up to the place of so-and-so brother of Major Manzoor of so-and-so arrested along with his wife, another person from paternal residence of his wife. The house of friend Khaden has still there since they were close to friends. It might be that brother Manoj and Nagma arrested from the residence of so-and-so. Not at all relevant. What it proves? It proves nothing. And somebody has to prove that this is the email that I have sent or I have received and these are the contents. Then this is also from Guwahati News they are referring to. Then your lordship will come to page 80. Page 80. Page 80. Last night, so-and-so picked up from the residence of so-and-so after that younger tailor to whose house so-and-so frequently stays was picked up. RO also picked up after they have been picked up. Thoiba and so on picked up morning at 2:30 a.m. from so-and-so residence and like reading. But my humble submission will be nothing is proved from here. They are all they were arrested and there was a news clipping. It was published in news. And they were arrested by sister police. And thereafter this, but then those contents have not been found. Then my lord, 82, my lord may come to 82. 82 I have already referred. Londhoni and Rakesh are on bail. Then exhibit 714, 115, 714 not available. Yes, no. So exhibit 115, 714 is not on record. 714 not on record. Exhibit 115/714. Not that it would have made some difference, but it is not there. Now, my lord, the 2 more left. Exhibit 5 series and exhibit 18 by 7. Exhibit 5 series is at page 1, my lord, of compilation 1 only.
Exhibit 5 series.
Exhibit 5 series. 5 series. It's all 115 from 115. That one. Page 16 of paper of compilation 1.
16.
16. Where is the? Now I may say, my lord, this was exhibited by PW 44.
Page 16, compilation 1.
My lord?
Page 16, compilation 1. It's
List of officers.
no.
This is an email and then there is that.
No, this is compilation 1.
Yeah, page 1.
Page 1. Oh, acha.
Page 1.
Yes.
This is an email list of officers is attached. Now, I may say, my lord, that this was exhibited by PW5, that junior scientific officer of Chandigarh. In original, he says all my seals are there, but it is not here. So this is a copy.
This was exhibited by BW.
5. M. Bhaskar. They don't write Bhaskar. Bhaskar. B-A-L.
He says this was in Maitai.
But he doesn't say anything. He has, because they transferred it. They have transferred the content. So it's not very clear. He'll be able to tell us. Because if your lordship kindly have this PW5 at page 34, compilation 3. This was not relevant for A6, so I did not. October 34. M. Bhaskar.
Yes.
I was working with Central Forensic Science Laboratory, Hyderabad, since so and so. Thereafter, I was posted to Central Forensic Science Laboratory, Chandigarh, as junior scientific officer. From 2011 September, I'm now posting as so and so. Then, related to physics, computer forensic, and voice identification, I have examined 16 cases in this. The issue is this, and I have submitted my report regarding examination. I think this background. In the instant case, CFSL laboratory, Chandigarh received 2 sealed closed parcels. Last paragraph at page 34.
Yes.
In this instant case, CFSI laboratory Chandigarh received 2 sealed closed parcels sealed with the seal impression corresponding to specimen seal impression forwarded from NIA New Delhi. After receiving these 2 exhibits, which are marked A and B by the NIA parcel A containing 1 hard disk, so and so, which was marked exhibit H1 in laboratory, parcel B containing 1 hard disk of so and so, which was marked H2. So they only received the hard disk. Then it says the said exhibits were opened by me and marked accordingly as aforesaid. After opening the storage media, white H1 and H2, I have forensically managed to into sterile storage media and analyzed using in case 6 version of so and so, so and so. Then, my lord, we'll skip that, come to 4. 3 zip files, name, draft, inbox, and send were present in file folders aligned array. The zip file that is draft, inbox, and sent with contents respectively 6032, the 2846 email files. The retrieved email file folders in and from exhibit H1 and H2 is provided in DVDR along with report. The extracted emails from inbox 66 and sent 30 files to a folder slide thread provided in CDR separately. 2 blank hard disks is returned along with the report to forwarding authority. Exhibit 1 is the examination report, so and so. After examining, the parcels were resealed and all. Your lordship, it's very clear that they received whatever they sent in a hard disk. And then at page 36, your lordship will see exact, I'll come straight to 5. So that is over. He exhibited 2 to 30. At present, we are concerned with 5 and 18, of course. Now, the third parameter, just below exhibit 2. Exhibit 5, your lordship will see. seventh line from top of paragraph 3.
Yes, exhibit 5.
Exhibit 5 is the said exhibit contents. I attachment, one attachment, namely officers list in page 5 of exhibit 5.1, signature on 5, exhibit 5.2 are the said page is an email, while exhibit 6 will not go to exhibit 6. So we are concerned only with 5. So he sends a list, he extracts from the email the attachment and marked it exhibit 5. Yeah.
Yes.
Now, 18 also your lordship sees, so we don't have to come back. At page 37. Page 37.
Exhibit 18.
18. The last 3 lines at page 37.
Hmm.
Exhibit 18 is the email dated 11/6/2010 from so-and-so to so-and-so, attachment under so-and-so. So, now this, so there is not even semblance of showing that there is a certificate. There is no certificate. Certificate is issued by 174, Siva Prasad Mohanty. He also same copied 53. He said, I'm in charge of this computer and the downloading was uninterrupted. This is what he also said. I'll show you what is the 74. Like this. Exhibit 74. Today also I'll not be able to complete it. 2 more will be there after this. Page 99. Yes. Page 99.
$99 of
Of compilation 1. I, Siva Prasad Mohanty, at Network Administration IT Wing of NIA Headquarters Splendor Forum, New Delhi, do hereby certify.
So 95, 99.
99.
99.
Exhibit 168. Don't you got it? I, Shiva Prasad Mohanty, Network Administrator, IT Wings of NIA Headquarters Splendor Forum, New Delhi, do hereby certify that the computer installed in the NIA office at New Delhi, from where data retrieved from email on disclosure of the accused R.K. Meghan, so-and-so in police custody, is under my technical control. I further certify that the process of downloading of the above email were uninterrupted. And you see, except the name of 19, and here it is in that place, name of 18 is mentioned at page 74. The Lordship will not find any difference. It is verbatim reproduction of each other. 53, certificate given by 53 and certificate given by 74. Purportedly under section 65 B4 of the Evidence Act.
Got a handle.
now I can take revenge against you
Yeah.
for all this volume.
Yeah.
I'll write an email to my brother and mark you as a terrorist with the conspiracy that I would lift so much and then become indisposed.
Then he is responsible for everything. He is responsible. And Dev Chaudhary was there, but NIA said, no, you be there because you are responsible, you conducted the trial. So, these emails are not at all, but no stretch of reasoning can be said because printout is being taken at CSF, Delhi, Chandigarh. And this for certifying downloading was uninterrupted. Maybe in uninterrupted or in uninterrupted, it's not the requirement of section 65B4. Requirement is that you certify that these emails were taken out from a computer which was under your technical control, and that it was being used in course of normal duty as per 65B2.
Please come to this evidence again of this PW, he is PW, Siva Prasad Mohanty.
He
Where
is
is,
74. He is PW 74. Page 81
81,
of one compilation fee.
comparison 3.
I think this is what you wanted that make a
No,
this,
yes, yes.
all the.
The chart was so that
participants want
easier,
to-
it's
Yeah.
easier for us to catch because we,
Correct, correct. We'll-
in a GP, we can't
It's a huge,
find out.
huge.
Because we wanted to correlate the evidence by way of this page 99 with his evidence that what is actually proved.
The Lordship will turn to page 81 of compilation 3.
Yes. You can come to 168 where he has said that.
168 is
Is page 82. I've shown so and so, I was near this vendor, this was.
74 has not exhibited any document. I forgot to tell my.
Pardon me?
No, he has not exhibited at all, 74.
No, this page 99, this 168. This is what you have read right now.
Yes. This is, on the same day, I prepared and signed a certificate as required under 165B of the Evidence Act regarding data received from email on the disclosure made by R.K. Megan, and I certified that the process of downloading of the email uninterrupted. 168 is the said certificate. It does nothing. No printout, doesn't say computer printout was taken in his presence. How secondary evidence will be admissible? Because my lord, PV Anwar PV and PK Bashir is the authority. Is the authority on this.
Because Mr. Mishra, this process of downloading, when it happens, now, let us say that this was a hushmail.com. I log into Hushmail and then give the password and the name, and it starts downloading. And it is the downloading, what was downloaded has been printed through a printer.
How? Unless it is certified, how can anybody say that? It's a secondary evidence. They should then place the computer before your lordship. Primary evidence will be that, and download it before your lordship. But they try to prove it through secondary evidence. And my lord, one thing your lordship always.
No, I've not been able to follow you. It has been downloaded.
It has been, that's what they say, it has been downloaded and download was uninterrupted.
Yes,
That's what it says.
correct.
They do not say that email was taken from these downloads. From here, the email I have taken out. They don't say that. Can that be presumed?
Because in the evidence it says, on the same date I prepared and signed a certificate as required and so and so. Regarding the data retrieved or email, I certified the process of downloading email was uninterrupted. So you are only trying to say that it is the printout of the same downloaded.
We don't know.
It's not stated. That
No,
is why,
even if it is, for example, I'm saying it is a state. What had happened in Bashir case? Bashir, in Bashir's case, Supreme Court overruled Navjot Sandhu case. In Navjot Sandhu case, there was an evidence that these are been printout have been taken. But they say, and Arjun Pandit says cannot be proved aliunde. There is no alternative vote to prove these secondary evidence, except by way of a certificate. And kindly see 65A of the Evidence Act. 65A of the Evidence Act. ये आगे पीछे मत बोल क्या Kindly see 65 capital A of the Evidence Act. I have annexed it. It is there in.
Just a moment. I just putting my voice the suggestion gave my brother that you are trying to say that not only the download, but the certificate must also say that it has been printed out, the printout was from that data.
That downloading is not necessary. Even without downloading, it can be printed. This is what I am told. Downloading is not required. If something is there, attach anything, and I command and it gets printed. Not required to be downloaded. So now come to 65A. 65A of the Evidence Act.
Downloading is always not required.
Not required. Many things I get, my lord. Something is like electricity bill. Something I just say, don't download it. I give command and it's printed out. Not required.
Not required.
Then they have downloaded it into the hard disk. That is how they have downloaded and sent it to CFS. So it's a secondary evidence that will have to be unless he says it's primary. Kindly see 65A.
Yes.
A special provision as to evidence relating to electronic record. The content of electronic records may be proved in accordance with the provision of section 65B. No other way. We kindly see this again, that Arjun Pandit case. Compilation 2, Arjun Pandit is 2020 at page 113. 113, compilation 2. Three judges bench. Relevant is at page 114, compilation 2.
Yes.
Paragraph 61. We may reiterate, therefore, that the certificate required under 65B4 is a condition precedent to the admissibility of the evidence by way of electronic record, as correctly held in Anwar PV and incorrectly clarified in Safi Muhammad. Safi Muhammad says the evidence can be given. Oral evidence in place of such certificate cannot possibly suffice, as section 65B4 is mandatory requirement of law. Then I'll not go to Sugar and Taylor. 62, your lordship will see. 62(1). In view of the above, the decision of Madras High Court in K. Ramajayam, which states that evidence aliunde is alternative.
Alternative way.
Yes, can be given through a person who was in charge of the computer device in place of requisite certificate under section 65(4) of the Evidence Act is also incorrect statement of law and is accordingly overruled. And on one, this Bashir case, I placed my lord, Navjot Singh Sandhu was also overruled.
Yes,
Your
that,
lordship will remember.
that took a note.
Yes. So there is no way that it can be proved otherwise. Alternative way. Now, the only two emails are left in this case, and I'll conclude in this case, of course. And my lord, at compilation 1. Page 1, your lordship. Compilation 1. This exhibit 5, which I have shown, is taken out by PW5, and this is without any certificate. Your lordship will come relevant at page 2. Page 2 of. Now, well, if, I don't see anywhere, mind me, Ganesh Singh. But serial number 5, if my lord will see, this has been taken as me. Here, serial number 5. Lieutenant Colonel Sinam Wangling, alias Guneshwar. Now, my name as per chart sheet at page 68. This chart sheet is should be take part 1, volume 1. Part 1, volume 1.
Part 1, volume 1. Yes.
Page 68. Your lordship will see at page 68, my name is
Yes.
Sinam Gunesing,
Alias boy.
alias boy, alias Wangling, alias little boy. That in the charge that was framed, in the charge that was framed, I'll not go to 31 because I have an next, in this volume only, page 137, if my lord will kindly. In this volume only,
Page,
page 137. Yes, part one, same.
yes,
Serial number 7. Sinam Gule Singh,
same.
same. So, I don't know how. Now, there's one more left, exhibit 18.
Please come back to your, the original one which you are trying to show. I forgot the track.
Original one I'm showing from chart sheet, page 68, paper book 1, volume 1. Part 1, volume 1.
No, that compilation,
Compilation chart sheet is not there.
no, that name you were trying to show this.
Yes, that
Huh.
is in from compilation, otherwise here it is one thing.
One,
Page 2.
oh, acha. Page 2, oh, acha.
That name is not in the chart sheet or in the chart.
No.
One should say that both are same person. Someone has to come to the court, take the witness box and say. I think I'll continue tomorrow, Lord, I can't stand it. I'm having a lot of problems. Your lordship is having single bench.
Oh, time to write otherwise also.
I get tired. 3 days are pretty start. Tomorrow I'll finish. If family is convenient.
The Commissions of Mr. D.K. Mishra, Senior Counsel, assisted by Mr. B. Prasad, Counsel for the appellant, remains inconclusive. Mr. D.K. Das, Senior Counsel, assisted by Ms. G.D. Chaudhary, Counsel for Respondent number 1, and Mr. R.K.D. Chaudhary, and DHGI, appearing for the Union of India are present. List has a pattern matter on. Tomorrow, 7.
Tomorrow will finish, and that I'll finish. Only 2 are left. One will take some time, other 2 will be.
The counsel for the other appellants, other connected appeals are also present.
After Gunathar, he begins for the rest of the accused, we'll start.
Hmm?
After Gunathar, he is for the rest of the accused.
No, we'll rise because we'll continue tomorrow.
May I make a humble submission, my lord? My learned senior, Mr. Sir is concluding his argument tomorrow. And tomorrow I have some unavoidable circumstance. Can I start my, because Sir has already covered, I have to just read your fail. Can I do it on Monday, sorry, Friday, my lord? This week itself, on Friday? This week itself, my lord.
We'll sit tomorrow. We'll just take a note of it.
Lord, because Friday I'll start my argument, I'll conclude within 2 hours. I don't know, because Sir has got.
You just renew the prayer tomorrow. We'll consider.
Station of Mr. M. Ali, your lordship. The matter may be passed over for the day, only for the day.
You want an adjournment? Just a moment. Item 3. This I've only put you one question. And for that, you have taken adjournment thrice. Question was put on 18/10/2023. We are in February now.
I don't know what's the, yes, your lordship. Perhaps it is, I for cancellation of bail order.
I understand. When I'm asking that question, I'm giving you dates. You must understand that I remember it. This is not convincing. And I'll give you the reasons why. You can't keep that. Cancellation of bill would not be in that. But Mr.
Yes. I am S. Islamian.
S. Islam. You're not on record?
No.
Then I'll not pass orders in your presence then. Okay. On behalf of learned counsel for the petitioner, the applicant, prayer for adjournment is made by Mr. S. Islam, learned counsel. Miss and thus learned APP is present. Matter stands adjourned today, list after 2 weeks.
Item 4.
No, the one. Item 4 is motion. Okay. 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 But this is not an order for modification. Why it has come here?
And that's earlier, this revision is filed by the defendants in the commercial suit. Earlier, the plaintiff, who are the respondents here,
No, but this matter can't be tied up with me.
my lord, because there was an initial order by your lord. While disposing of.
No, you see, this is not a review.
Fine, I understand.
Not being a review, why should the matter be tied up with this court, this bench?
Matter had come up for this honorable justice P.J. Singh. He heard the matter and then
Oh,
since he saw your lordship's order while disposing of the FAO, because certain directions were given to the trial court. dispose of the injunction application within an outer limit.
Where is the order, the earlier order?
Your lordship order is 187, annexure 23. Starts from page number 189. Operative parts. Para 3, my lord. Direction was. I may read the order.
Now, what order has been passed thereafter?
Yes. Thereafter, my lord, on 2/11/2023, your lordship will find at page number 204.
204.
Yes, 204, reappeared after that, my lord. On 2/11/2023, my lord, the operative part of the order is at page number 207. The last para of that page, my lord. At this juncture, it is pertinent to reflect that although the order dated 18/10/2023 made it apparently clear that the learned trial court shall not be influenced by the order of ad interim injunction granted by the court on 2/6/2023, and which is extended till appearance of the parties before trial court till 2/11/2023, and after which the matter is to be decided in its own merit without being influenced by the said order, yet it is also pertinent to reflect herein that an ad interim relief is provided to the petitioner by the Honorable Guwahati High Court, which is in subsistence up to today, that is 2/11/2023. Keeping a note of the facts and circumstances of the case, as well as in the greater interest of justice, coupled with a direction to this court to conduct expeditious hearing of the instant case, henceforth keeping in view of the mandate of expeditious hearing of the matter, as well as the position of the parties which has been till date as per the order of Honorable Guwahati High Court, I am inclined to direct the stakeholders of this case to maintain status quo as on today, till next date, keeping a note of the possibility of inconvenience likely to be suffered by the petitioners owing to the absence of such an order. However, it is hereby made clear that as the matter has been referred for expeditious disposal by the Honorable Guwahati High Court, therefore both the parties are directed to ensure that the hearing of the instant mistake case take place without undue delay, and that too within a short span of time. Being so, the next date, if fixed for filing written objection against the prayer of impleadment filed by the firm, namely Messrs. Suryakant Singh, bearing petition number 5914/23 dated 27/9/2023. Fixed 28/11/2023 for written objection. On that day, my lord, that's on the next page 209, the order dated 28/11/2023. Both sides are duly represented. Learned counsel for Mr. Suryakant Singh has marked his appearance in the instant case. The petitioner has submitted written objection against written objection, my lord, of the opposite party dated 12/9/2023. Copy be furnished to opposite party number 1 and 2, my lord. Also, the learned counsel for the petitioners has submitted written objection against the petition number 5914/23 preferred by Mrs. Suryakant Singh. Copy of the same be furnished to the other side. The status quo order dated 2/11/2023, which was extended by the court till today, is extended further till next date in view of this order, as well as the prayer made by the petitioner by petition number 7000/23, fixed 15/12/2023 for hearing of the necessary orders. My lord, they were supposed to take the hearing trial court on the next date, my lord. No reason is assigned.
But what is your prayer here?
Here, my lord, ultimately an order is passed now. That is at, my lord, page number 200. Annexure 26, page number 211.
2-1?
211, operative part, my lord, starts from 212. Now this order is passed in the main suit, my lord. Both sides are represented along with petitioner Surya Kant Singh, who has appeared with a prayer for impleading him as a party in the instance suit. Today was fixed for written objection necessary order of the hearing. Learned counsel for the plaintiff has submitted his written objection against the prayer for impleadment.
No, we are not concerned. The last order of this court is no connection with commercial suit. It was an injunction application.
Now,
Then-
due to this order, the hearing in the Miss case has been deferred. Right. Hearing has not been taken place. Was supposed to take the hearing, my lord, after the objections were filed on, my lord,
No, what is your prayer here?
here, my lord, that the injunction application and what other miscellaneous applications should be heard within the time frame as granted by this honorable court, my lord.
But then we have to only issue a notice. We can't do anything. It can't be disposed of.
My
Ex
lord,
parte disposal can't be made.
my lord, the thing is that if your lordship would come here, kindly see the third paragraph. Upon hearing learned counsel for the plaintiff as well as the engaged counsel for Surya Kanta Singh, it appears that there was some conversation taken place between the parties for which the final say and hearing of the board members along with principal of DPS Duliajan is necessary. My lord, we have already filed the objection. We have said everything, my lord. What was the requirement of final say from the governing body of the DPS school, my lord? And the
Page,
page, my lord, 212, my lord. Page number 212, my lord. Upon hearing, the lordship has found. The governing body members are not the party to their suit, my lord. And,
Where is the plaintiff?
my lord. Plaintiffs are, my lord, page number 156.
156.
Annexure 19, my lord. My lord. It's being represented by the principal. Principal is the party. Only two defendants, Delhi Public School and then principal Delhi Public School represented by them.
But Mr. Z. Bukit, current counsel for the petitioners. By filing this application under Article 227 of the Constitution of India, now the petitioner has assailed the order dated 11/1/2024 passed by the learned civil judge within bracket senior division bracket closed Dibrugarh in commercial suit number 2 of 2023. Stop. The case of the petitioners is that this court by order dated 18/10/2023 passed in IA Civil 2540 of 2023 in FAO 25 of 2023 which related to orders passed in injunction application amongst others had directed the the learned's trial court to take the proceedings of MISJ case number 74 of 2023 as expeditiously as possible without granting any unnecessary adjournment to either side, and make an endeavor to dispose of the said application within an outer period of 1 month. Full stop. There is next para. It is submitted that for one reason or the other, the proceedings of MISJ case number 74 of 2023 has been kept pending and not disposed of, and the interim orders as passed by the learned trial court on 2/11/2023 was extended from time to time. Next, but it is further submitted that in connection with an impleading application, the learned trial court had passed an order dated 11/1/2024 in commercial suit number 2 of 2023, directing the principal along with members of governing body of DPS along with the plaintiff to appear personally before the court on the date fixed. First, it is submitted that the governing body of the DPS are not parties to the suit. Moreover, it is submitted that the principal of DPS, who is arraigned as defendant number 2 in the suit, had already filed a written statement in the suit as well as objection in the impleading application. Hence, it is submitted that
Impleading, we are not opposing as defendants.
you are not opposed that.
Impleading, we are not opposing.
As I didn't say, it's submitted that the impleading application is not being opposed by the by the petitioners. Full stop. It is submitted that objection has been filed in connection with MISJ case number 74 of 2023. And presence of parties are not and it is submitted that presence parties are not required at this stage, either in the suit or in connection with the injunction application. And accordingly, the prayer is to the effect that the personal appearance of the members of the governing body of DPS be dispensed with. Next paragraph. Issue notice returnable in 4 weeks. Give date after 4 weeks. Petitioners shall take steps for service of notice on the respondents by registered postal ID Next, till the next returnable date. The operation of the order dated 11/1/2024 passed by the Learned Civil Judge within bracket senior division, bracket close, Dibrugarh, in commercial suit number 2 of 2023 shall remain stayed. Next para. Insofar as the direction of the court in containing order dated 18/10/2023 in IA Civil 2540/2023 in FAO 25 of 2023 is concerned for expeditious disposal of the injunction application. The court is inclined to permit the petitioners herein to once again produce a downloaded copy of this order before the learned trial court to bring to its notice the directions contained in paragraph 3 of the said order. Next, the court is inclined to permit the petitioners to produce a copy of the order passed by the learned trial court on the next date before this court on the next date of hearing. List after, list on. 18. What is there? This para, as this CRPIO is independent of the earlier order of this court. Hence, this matter shall not be treated as a tied up matter before this bench. Given except on endorsement bit. Unless the matter is assigned to this bench by orders of the Honorable the Chief Justice.
Item 1.
And therefore it can be listed before any other bench. The appropriate bench taking up civil bench 1 matters. List on so and so purpose. Yes. Yes.
That's why your lordship will find page 25.
Where is the earlier order passed by this bench?
Here, order your lordship will find at page 66.
66. The scanned copy of the LCR was available in the earlier record.
That's the figure your lordship said.
Oh, yes, it is available.
Shiv, I have not run through the LCR, Worship. Kindly.
No, no. No, it's not a scanned copy of the LCR which we got. We the relevant details are available here, and we had only directed order sheet from after 9/10/2023 to be produced. This is to, it's there, I have kept it in the third, what do you call it, the third fold. It is there, you can just go through it. We only wanted to know about the status of the trial. After some time, let us go through it.
Ground I have taken is that the search and seizure were made at night. Whether that the search and seizure were made at night, that is at 2:20 AM. Whether that authorization was there with regard to that, that probably will require that scan copies.
At the bail stage, we were not.
I am supporting the rule of Supreme Court, which is if it is 42 is not complied with, then bail can be given.
Let us examine that because that aspect we have not,
There
it
were-
did not catch my notice. Okay, let us see it, then we'll see it about it.
Next item, nothing. Item 2.
The constitution is prepared against an order caused by your my lord, which your lordship will find a place would be.
We had posed a query that whether non-consideration of an earlier judgment of the Supreme Court of India, which was not placed when the matter was heard, can be a ground for review.
Yes. In this connection, lordship, may I? With two judgments, one of the Honorable Supreme Court, that is 1964 C 1370.
19?
Yeah, 64 C 1370. I have a print. And number of the Orissa High Court. Yeah, 1964. 1370. Also, Orissa High Court. Patina Province, elected Katak Commerces, Bharat Chandra Pia.
You are now referring to 64 Supreme Court?
Yes.
Yes.
If I may take your lordship, paragraph 11, that your lordship will find at page 5.
Para 11.
Page 5, below.
Yes.
What, however, we are now concerned is whether the statement in the order of September 1959, that the case did not involve any substantial question of law, is an error apparent on the face of the record. The fact that on the earlier occasion, the court held on an identical state of facts that a substantial question of law arose would not per se be conclusive. For the earlier order itself might be erroneous. Similarly, even if the statement was wrong, it would not follow that it was an error apparent on the face of the record, but there is a distinction which is real, though it might not always be capable of exposition, between a mere erroneous decision and a decision which could be characterized as initiated by error apparent. A review is by no means an appeal in disguise, whereby an erroneous decision is reheard and corrected, but lies only for patent error. We do not consider that this furnishes a suitable occasion for dealing with this difference exhaustively or in any great detail, but it would suffice for us to say that where, without any elaborate argument, one could point to the error and say, here is a substantial point of law which stares one in the face. There could reasonably being no two opinions entertained about it, a clear case of error covered on the face of the record would be made out. Now, relying on this judgment, lordship, this particular paragraph, I take your lordship to a judgment rendered by the Honorable Odisha High Court. Can I take your lordship to paragraph 13 that your lordship will find at page 4? Article 141 of the Constitution provides that a law declared by the Supreme Court shall be binding on all courts within the territory of India. Where there is a decision of the Supreme Court holding the field and the High Court takes a contrary view, it needs no elaborate argument to point to the error. The error is self-evident. It is held in so and so, lordship, that is. Now, in the instant case, what had happened here was, lordship, there was a case of the Honorable Supreme Court, which, lordship, apparently I could not bring to the light of this Honorable Court, and which I have annexed with my review petition, lordship. At page 24.
Yes.
In the instant case, the lordship, the petitioner was removed from service pursuant to exercise of powers under section 11(1) of the CRPF Act. And lordship had discussed section 11 and 12 in paragraph 9 of lordship judgment at page 18.
Which page? 18.
Page 18, lordship. Paragraph 9 that extracted provisions of section 11 and 12. And ultimately at paragraph 10, if I may read, lordship. From the above, it appears there is no provision in section 11 of the Maritime Act to award imprisonment to the CRPF personnel or any employee who is subjected to the Act of 1949. From the provision of section 12 of the Act, it appears that every person sentenced under the said 1949 Act to imprisonment may be dismissed from force. Now, this line, lordship. In the present case in hand, as the petitioner was not awarded the sentence of imprisonment, the petitioner could not have been dismissed from service, and therefore the appellate authority appears to have rightly set aside the punishment of removal from service. But if I may take your lordship to the judgment of the Honorable Supreme Court at Annexure 2, page 24, the relevant page, if I may take at page 27, At page 26, Lordship, the provision of section 11 is taken. At page 27, paragraph 5 of the judgment, the bare perusal of section 11 shows that it deals with minor punishment as compared to the major punishments prescribed in the preceding section. It lays down that a commandant or any other authority or officer, as may be prescribed, may, subject to any rules made under the Act, award any one or more of the punishments to any member of the force who is found guilty of disobedience, neglect, or duty or omissions in the discharge of his duty or other misconduct in his capacity as a member of the force. According to the High Court, the only punishment which can be awarded under this section is reduction in rank, fine, confinement to quarters, and removal from the office of distinction or special emoluments in the force. In our opinion, the interpretation is not correct because the section says these punishments may be awarded in lieu of or in addition to suspension or dismissal. Next paragraph. The use of the words in lieu of or in addition to suspension or dismissal appearing in subsection 1 of section 11 before clauses A to E shows that the authority mentioned therein are empowered to award punishment or dismissal or suspension to the member of the force who is found guilty, and in addition to or in lieu thereof, the punishment mentioned in clause A to E may also be awarded. Lordship, if not bring to the notice of this honorable court this particular judgment when the matter is being heard.
But still, this same observation stands. Here he suffered a corporal punishment. Correct. That is what I read from this para 10 of the order. From the above, it appears there is no provision in section 11 of the Act to award imprisonment.
Lordship, here he was charged by the civil court. Civil court means the normal court. He was charged by the civil court. He was not imprisoned by the civil court.
Every person sentenced under the so-and-so Act to imprisonment may be dismissed from force. The present case in hand petitioner was not awarded the sentence of imprisonment. The petitioner could not have been dismissed from service.
That is what Lordship is.
Now, this 11 says, the commandant or the authority may be prescribed may under the rules subject to the award in lieu of or in addition to suspension or dismissal any one of the following punishments to the member of the force whom he considers to be guilty of disobedience. In lieu of or in addition to suspension, dismissal, in lieu or in addition to suspension or dismissal.
That has been explained by the Supreme.
Okay. So that is the only point. Yes, Sharma.
My pleasure. My lord, this is a review application. In the review application, as you know, there must be illegal in the case of the record.
He's persuading us from this. That's so division bench judgment of Odisha High Court saying that the or the orders and judgments passed by the Supreme Court of India would be a binding law under 141, and therefore, if correct law is not applied, it's an error apparent on the face of record. That is what he's trying to say.
What I want to submit is this. If there is an error apparent on the face of record, if the judgment is totally illegal, not according to law, the course open to the petitioner is to prefer an appeal, not by way of review. Because their door is open to prefer appeal. Because this, if any illegality or irregularity is committed in the impugned judgment, there is a provision for appeal. Therefore, even though this judgment says, therefore, and your lordship has passed the very elaborate judgment. Therefore, on consideration of the judgment, it cannot be a ground for review of the. Therefore, their course, their roads are open to the higher authority, higher court, and by way of review, this cannot be taken into consideration. My prayer before is, as there is no error apparent on the face of the record in the impugned judgment, therefore, the review petition is liable to be rejected.
Arguments. The submissions of Mr. R.K.D. Chaudhary done at DSGI, as well as Mr. A.C. Sharma, Senior Counsel, assisted by Mr. J. Hathimuria, done at Counsel for the Respondent, is concluded. List on Friday. List on so and so for delivery of orders. Go to chamber.
Item 1.
Township, as per the order dated 19/1/24,
But Mr. Ahmed, I think she will require that LCR, because whether if you're taking that plea, that she'll be then entitled to look at will be required.
township, fixed it on 3/2/24 for production and evidence and 16/2/24 for report. And today is 6th, Lordship, so let the matter come after 16, Lordship.
So we'll have to call for the scanned copy of.
Special NBPS case number 74 of 20.
No, in the previous application, we'll have that.
Page 66, you will find paragraph 3. Page 67 is a relevant question. Paragraph 3.
I just want to know whether the scanned copy of LCR is available or not, only that one.
Further, in page 61, your logic will find that another quote is on granted grade. In that case, logic record to as well.
Which page?
Page 61.
61. It doesn't say about the record.
Logic on page 62, paragraph 4 and 5.
62.
Paragraph 4 and it's also said about from the
Okay, this matter on. uh, 15 to 2020. Four, along with records of BA 3234 of 2023 and BA 3415 of 2023. 3415 2023. And BA 2999 of 2023. Let us see if it's not there, because then we'll have to call for the
I have been informed that after that order was passed, one witness is examined. I will be allowed to produce a certified copy on the next day.
before that, right? On the prayer made by Learned Counsel for the Mr. Ahmed, Counsel for the petitioner is permitted to file additional affidavit to bring on record witness if any examined by the prosecution after filing of this application.
Okay.
Date is 15/2. Huh?
19th.
You want to 19th? 19th January, okay.